Apologies. Draft minutes, pages 5. Referring to the meeting of the 16th of September, members content that the draft minutes are an accurate record.
Right.
Matters arising, table of requests for information from the department, pages 12 of your packs. For noting, NAMA, correspondence and next steps. We've received a considerable amount of correspondence in regard to the NAMA review that we're carrying out. There's correspondence from the former DFP Permanent Secretary Stephen Pover indicating his availability to give evidence. That's at pages 3 to 4. Correspondence with John J. Rice and Company indicating Mr. Frank Cushnahan's willingness to respond to written questions. Pages 5 to 7 of table of correspondence from Mr. Paul Tweed, Johnson Solicitors, with reference to the evidence to be received from Mr. Bryson at pages 8 to 9. Correspondence from the NI Editors Liaison Group raising various concerns in relation to the committee potentially setting a precedent for redaction and suppression of evidence at pages 10 to 12 of your table packs. Pages 13 to 15 are an updated summary of outstanding requests. The terms of reference, pages 16 to 17, and procedural advice 18 to 19. Can advise members before making decisions arising from the correspondence. There are a couple of outstanding issues which may need follow-up actions. Can I remind members, following the oral evidence from the Permanent Secretary on the 23rd of July, the committee agreed to ask the Department to clarify various matters, including the status of the various papers provided to the committee. The Department has still not responded to the committee's queries some 2 months later, so we're giving them ample opportunity to respond to a request. And in the absence of a response from the Department, are the committee content that we commission legal advice on publishing the DFP papers that we already have received at the start of July? Content? Great. My Members Committee previously commissioned research to provide an updated NAMA timeline. This is due to be received by the end of this week. Can I seek agreement to publish the updated research paper once it's made available? Agreed. Correspondence from former DFP Permanent Secretary Stephen Pover, pages 3 to 4 of your table pack. Can I seek agreement that the evidence session is scheduled into the committee work programme, and that in line with the committee's previous approach, research is asked to prepare questions, and that members will also have the opportunity to submit questions for the session. These will be considered by Assembly Legal Services as a safeguard in ensuring that the committee remains within its terms of reference before being agreed by the committee for issuing to Mr. Pover. Members content? Agreed. Correspondence from John J. Rice and Company on behalf of Mr. Frank Cushnahan, pages 5 to 7. Can I also seek agreement that research is asked to prepare questions and that members will also have the opportunity to submit questions for written response to Mr. Cushnahan. These will be considered by Legal Services as a safeguard in ensuring that the committee remains within its terms of reference before being agreed by the committee for issuing to Mr. Cushnahan. Agreed?
Sure, I think, if I may, and of course we agree with that, and let's submit other questions, but we aren't a correspondence committee. We're supposed to be a committee which hears evidence. It would be very convenient for everyone if your engagement with us was by letter, but that's not what we're here for. We're here to bring people to task, to ask them what happened, to hear evidence, and I really don't want to end up in some sort of pen pal relationship with any of the people we have asked to give evidence. And that goes, of course, for Mr. Cushnan, it goes for Mr. Roundtree, it goes for others. So let's proceed with some caution, because we ask people to answer other questions shouldn't mean that we have given up on the possibility of compelling them to give evidence here. That is, and we will discuss this later, but our entire remit is to be a public body trying to bring some light to bear on this dirty scheme. And if we reduce ourselves to a pen pal committee, I think we're wasting our time. So happy to submit other questions in relation to the correspondence from Mr. Rice on behalf of Mr. Cushnan, but I do sound a warning which I'll come back to later on if necessary.
Okay. Moving on, correspondence from Mr. Paul Tweed, Johnson Solicitors, pages 8 to 9, and correspondence from the NI Editors liaison group, pages 10 to 12 of your table of packs. Can I advise members that both of these pieces of correspondence relate to today's witness sessions and whether the evidence is heard in public? Can I advise members that I have sought clarification on who Mr Tweed is representing in respect of his letter? He has since come back this morning to state that he is representing a total of 6 individuals, but he has not named them at this stage as doing result in further dissemination of defamatory material under the protection of privilege. So he is representing, he said he is representing 6 individuals, but has not named them.
I think, Chair, if I may, I hold Mr Tweed in very high regard, but I don't think you can write to this committee saying you represent clients and then say I'm not going to name them. It's a matter of public record that he represents the First Minister in his correspondence with TD McWallace this week. But who, I don't know, the First Minister is one of the 6. But I do think that if he wants to write into us to tell us how to conduct our business, we need to know who the clients are. And I don't know if you're saying you've seen the names, Chair, or the names haven't been revealed by Mr Tweed.
The names haven't been submitted to the committee staff or members that I'm aware of. So,
well, I don't find that acceptable. If the NCA can come here and talk to you, then surely Mr Tweed can tell you who his clients are. And if we want to protect and give everyone fair play, and you decide to read that letter and see those names and then proceed as you advise, I think we're willing to be flexible in these matters, but wholly unacceptable for any lawyer, no matter how highly respected, to send us correspondence but refusing to tell us who he represents. Not a legal expert, but I suspect it's without precedence.
Okay, Deputy Chair.
Thanks, Chair. Yeah, I think it's a bit unusual that Mr Tweed should write to the committee and express his reservations about what might be said by witnesses about his clients, and then not be prepared to tell us who those clients are.
Okay.
So we need to write to Mr Tweed, and as far as I'm concerned, I'm not going to give any weight to a letter which doesn't tell us who the clients are, or doesn't tell the chair or the deputy chair, or even a member from each party, as we're doing with the NCA in terms of meeting the NCA. The National Crime Agency said they wanted to meet with the chair and deputy chair. We said no, we think you'd meet with the representative of each party as well. So I don't really mind how we cut this, but I'm not giving any weight to a letter from a solicitor, no matter how highly regarded, who doesn't say who his clients are, who doesn't reveal that to the chair. So I think we need to write to Mr Tweed and ask for that information.
Okay, Tim.
So we are dealing with one of Northern Ireland's most foremost legal practitioners. So, I mean, this is a gentleman who knows an awful lot more about any legal points than you or I or anybody else in this room. I presume that part of the reason is that he's been asked by several of his clients not to reveal their names, and that's entirely in order for him to make a contribution. You can ask, but if that's the basis, then he'll not be responding. He'll not be naming anybody.
Okay, members, happy to move on, agreeing to that approach. In terms of the committee's approach to the oral evidence scheduled today, I remind members of the committee decided last week that its general approach in taking further oral evidence will be on the following basis. One, where a witness can demonstrate their direct link with any of the parties referred to in the review terms of reference. Their oral evidence will be taken in public session, with the proceedings transmitted live and published in full in the official report by Hansard. And option 2, where a witness is unable to demonstrate their direct link with any of the parties referred to in the review terms of reference, their oral evidence will be taken in closed session with no live transmission of proceedings, but with a verbatim transcript being published in a redacted form if necessary, with decisions on any redactions being taken on the basis of legal advice. Can I advise members that as a consequence of this decision, they should be clear that it is ultimately for the committee to decide on the extent of linkage between a witness and the review terms of reference, and that the committee can decide to invite a witness to give public oral evidence on the basis that it is content that the necessary direct linkage exists. So I hope you got all that. Can I advise members that the witness is scheduled to provide oral evidence today? Were advised of last week's decision, and correspondence has been received from them in that regard. Correspondence from the Deputy First Minister is at pages 16 to 20 of your main pack and page 24 of the table pack. And correspondence with Mr Jamie Bryson is at pages 63 to 65 of the main pack and pages 165 to 171 of the table pack.
Chair, there was further correspondence from Mr Bryson received last night, and it's just been copied as we speak. The image wasn't good, so we had to get a better quality image, so that's been copied.
Okay. Can I advise members that the committee can now decide its approach separately in the case of both witnesses? So if we take the approach to taking oral evidence from Deputy First Minister first, as he is the first witness before us today, can I take members' views on whether they wish this to be in open session or a closed session?
Open session, of course, Chair.
Open session.
Yes, open session, Mr Chairman.
Mr Chair, it's quite clear that Mr McGuinness has had direct contact with the players here and has met them, so therefore it's appropriate with the open session.
Okay.
I make no comment.
Just if you've got it in. It's just waiting.
Members can we take a break for a couple of minutes until we get correspondence copied? Great.
Committee Room 30. This is the Northern Ireland Assembly Committee Room 30.
Now in live session again. Okay, I can advise members that following Mr Bryson's email response at page 167 of your table packs, the committee staff are in contact with him to establish when he would be providing the supporting documents referred to, so that members have sufficient time to consider them. In response, Mr Bryson confirmed that he intended to provide these once he made his opening statement. He has, and you have a document in front of you, provided one document from his file, so to speak. So members will have had time to look over that. So can I take members' views on whether to take approach 1 or approach 2, open or closed, in regard to Mr Bryson?
Well, Mr Chairman, I mean, we've got a document. I don't actually understand fully what it is, but it's basically 2 pages, A4, with next to nothing on them. With 2 names. I mean, I'm just wondering, is this the extent to what Mr Bryson is claiming to be the documents he has? Could these have been obtained just by going down to the law courts and getting photocopies of them? What do these prove? Do maybe the clerk have a bit more information as to what these are?
Which I have no further information to add.
Leslie?
Mr Chair, I think, bearing in mind what the last speaker said, there's nothing for us to fear in hearing this gentleman in public session. And I would so propose.
Sir, second, what Leslie says, on grounds that I outlined last week, that this is an inquiry which should be open and transparent, and I think holding sessions behind closed doors and redacting transcripts is not open and transparent, and will certainly lead the public to the view that this inquiry is not a genuine attempt to get at the truth.
Judith and Martin?
Yeah, I mean, I think the stuff that's been provided to us this morning, I'm not really sure what it's relevant to, so I'm basing it on Mr Bryson's response to the committee, to the letter that we asked him. And I guess most of that response was critical of our approach. It wasn't actually answering the question that we asked him, but I did get down into, I think it was paragraph 6. So there was one little section where he did refer to some sort of, primary documentation and that kind of thing. And I actually think before I could take a decision on this, I would actually like perhaps to have Mr Bryson in, just so that, because I don't feel he's answered our question in that, but I don't want to immediately then turn around and say, no, we're not hearing him just because he hasn't answered the question. I would like to give him that opportunity, in the interest of transparency, to just ask him which of the 4 objectives he feels he really has the direct information related to, because what he's put there, to me, doesn't necessarily meet it, but it may be that he has it, he just hasn't actually clearly put it in the letter. So rather than say, no, we're not going to hear from him, I would like to give him that opportunity. It's not to take his evidence at this stage, it's just to bring him forward and check that he's read the objectives, that he understands them, that he knows that what he has to answer us is about facts, because that's what we're interested in, and you know, which of the objectives he feels he's going to be able to assist us with. I think that would be a balanced approach.
Okay, Martin.
Well, I think that's a middle route, and if it gets us a chance to tease out Mr. Bryson, I think that would be a good thing. Chair, you have an onus responsibility to make sure that Mr. Bryson sticks to the criteria, and agreeing to have him appear at this committee, and I'm in favour of maximum transparency in a full public session. It's my belief that you will make sure he doesn't stray from those criteria. I want to put on record, I believe everyone in this committee wants to get to the truth of this dodgy deal, of these kickbacks, of these sweetheart deals, of this £7.5 million payment. But I also want to say that it's great to see a full turnout. When we spoke with refugees yesterday, all the gentlemen opposite, with the exception of Mr. Cree, weren't there. It's good to see it's business as usual today. But business as usual means exposing the fraudsters, the people involved in embezzlement, the people who are trying to rob the public, and this Mr. Wells says the taxpayer in the south of Ireland, of £7.5 million. So I think that while I've expressed reservations about Mr. Bryson, his politics leave me cold, but he has the right, as everyone else has, to appear in front of a public investigation. So if Mrs. Cochrane is saying let's get him in to tease out where he is, I think that's a good starting point.
Okay, Jim.
I have no objection to what Mrs. Cochrane's suggesting, but I feel it should be held in private session. But there's nothing to stop us as a committee testing Mr. Bryson's efficacy by teasing it out in a private session, because again, we run the risk during that he may say something which could damage it.
Well, Chair, I thought Mrs. Cochrane was talking about a public session. She's now talking about going into private. No.
Excuse me. Please don't try to say that I'm trying to go into private again. I would like it to be an open session to ensure that he understands the terms of reference, and that he understands that any of the information that he is giving us is directly in relation to the bodies named in our investigation. He may have other information, he may have information that is completely relevant to the National Crime Agency, and I urge him to make sure he gives that information. But it must be within our terms of reference.
I apologise to Mrs. Cochrane for picking her up wrong.
Mr. Chairman, can I propose an amendment to Mrs. Cochrane to actually do as she says, but have it in private session?
Okay, so John, you want to come in?
Just briefly, Chair, to declare an interest that Mr. Bryson had sent me a private message, you know, just in case that comes up, or I'm happy to share it with the committee if you feel that's relevant. But I was just making the case for appearing at the committee. I mean, I think it would be useful to tease out the linkages. I would probably support Mr. Wells's point that I would do that initially in private session. Not happy with the
So the proposal from Judith is to what exactly?
Do you have a proposal?
Mine's first of the year. Chair, you know, we've got now what looks like a second and an amendment to the second. So
you're proposing that we hear from Mr. Bryson?
Yes, I'll be treating it
without
everyone
any
else.
prior meeting.
Approach one.
Approach one. Approach two is that we.
Just before I take a decision on that, I would require some further clarification. Otherwise, I would have to abstain, and I'm not sure whether by abstaining on that you would actually get an answer one way or the other. So if you want to take a vote on that and end up that we're no further on, my proposal is to allow me to try and take a position one way or the other on Mr. Cree's proposal.
I support that. I would prefer to hear if there's any linkages before. And obviously, if Leslie wants to push it to vote, I would probably have to vote against at this stage.
Chair, just to be clear, that I'm clear that Judith Cochrane's proposal is not to commence the oral evidence session, but to seek clarification from the witness before commencing the oral evidence session.
The committee took a position last week that we would establish a direct link between the terms of reference and the information, the facts that are going to be put in front of us. I don't feel that Mr. Bryson has done that in his letter, but it may just be because he hasn't quite answered the question right. It may be that he can actually demonstrate it. If I take it at face value what he's put in front of me at the minute, I would have to vote to say no. But I'm giving him the benefit of the doubt and asking the chair, could we ask a couple more questions just on that, so that he demonstrates that link? That's all I'm asking, so that we meet the committee's approach that we decided on last week.
Well, thank you, Mrs Cochrane, for that clarification. Mr Chairman, we will be relying upon you to make absolutely certain that Mr Bryson does not stray from those basic points into giving evidence. That he's only here initially to demonstrate his linkage to the actual matters before us.
You'll appreciate as well this is going to be difficult if you're wanting answers from Mr Bryson without giving you too many answers in regard to as there is. So it is going to be difficult to try and control this, but I'll do that to the best of my ability.
Ridiculous comes to mind, Chair. There you are.
Okay, so we have 3 proposals.
Well, Mr Chairman, we will not, given the clarification from Mrs Cochrane, and given your assurance that you're going to keep things very strictly in line, then I think we can not push to a vote. In fact, he comes on this issue, on this particular issue, not then moving on to what he knows or thinks he knows generally, on this issue to show his relevance to the work of this committee.
I think you'd decide my proposition first, because it was made first and duly seconded. And if that succeeds, fine. If it's not, then you can take the second proposal out.
You're proposing that we hold an evidence session with Mr Bryson right away without a premium?
That's it, as we do with everyone else.
Okay.
Sure. Can I just ask, I mean, we have set down the terms of reference at the beginning of this query. Are these decisions which we are, about to take, do they in any way impact upon the terms of reference?
Repeat that, sorry.
So we have set down the parameters of the inquiry at the outset, and they've been voted on and agreed. Are these decisions that we're about to take, do they in any way alter the terms of reference?
I don't see an issue in that regard. If the committee would obviously be keeping within its terms of reference and taking any evidence, and would endeavour to do so.
I think it's fair to say there's.
But do the terms of reference not cover all of these issues, insofar as to set the parameters for the inquiry?
Linkage.
So the issue, Chair, is whether the committee is content, based on the information available, arising from its decision last week, whether Mr Bryson has a direct link to any of the bodies referred to in the committee's terms of reference. So in order to proceed, the committee needs to make that decision. In terms of moving back a step, on the 3rd of September, the committee agreed to proceed with oral evidence from Mr Bryson within the terms of reference. On the 16th of September, then it decided how to do that. So today it needs to decide how.
Okay, members, content to go to the vote. First proposal from Leslie Cree. All those in favour? All those against? Falls. Draw.
Sorry, Chair, it's 5-5, so it falls, yeah. There's no recorded abstention.
Well, you didn't ask for abstention, but I have made it clear I would abstain because there's not enough information in front of me at the moment, hence my proposal.
Okay, so Judith's proposal. Jim, have you withdrawn your?
Yes, I mean, you want to put to vote by all means, but on the basis of what Judith has outlined, we could live with that, but nothing more.
Okay, members content to proceed on that basis then? Agreed? Okay. Okay, members. Now we'll move into the briefing from the Deputy First Minister. Oh, yeah. Before proceeding with the evidence session, fair members, the procedural guidance note at pages 18 and 19 in your table pack. In particular, I can appoint members to advice regarding privilege. So is this table papers? Or
Page 19.
table pack?
Yeah, right, yeah.
Or morning.
Morning all. Morning. Good to see you.
Very much. First Minister, you're very welcome to the committee.
Thank you.
Thank you for taking time out of your busy schedule. I'm sure you have a lot of other things to be doing today down the road. Martin, we're just going to go straight into questions if you're content. There's two issues really for me. The first one that was raised a number of months ago was the issue of a memorandum of understanding coming from the First Minister's office. This was sent to NAMA in January 2014 and was remarkably similar to a proposal Sammy Wilson had sent to Michael Noonan on behalf of Browden Budnick, who represented PIMCO and Cerberus. Now, Frank Daly from NAMA said the memorandum of understanding appeared to summarise his quotes, an agreement between PIMCO and the NI executive. Was this memorandum of understanding ever brought to the executive?
No, it wasn't.
Did you see it, or were you aware of it before it was sent from the First Minister's office to NAMA?
No.
And procedurally, should this have been sent to NAMA without your sign-off within OFMDHM?
Well, the memorandum of understanding to be valid, coming from the Office of First and Deputy First Minister, required my and the First Minister's consent. Absent that, the consent of the principal private secretaries on our behalf, and that didn't happen.
The First Minister said, and there's clearly a divergence of views on this particular issue, he has said that there is a paper trail in the department that shows that you were aware of this. Are you aware of any paper trail within the department that would back up what the First Minister has said?
Well, after that was said, I asked my officials to do a very thorough check, and no such paper trail exists.
The second issue of concern to myself is a record of two conference calls in December 2013 and January 2014 between Simon Hamilton, who was then the Finance Minister, and Frank Daly from NAMA. Now, these were disclosed by NAMA to the committee. The Department of Finance and Personnel did not disclose any details of these conference calls and have yet sent us any information pertaining to this, which is of great concern to this committee. And it's my view, going on the minutes and the papers that were disclosed in late 2013, that Minister Hamilton was lobbying NAMA and lobbying Michael Noonan for a closed sale in regard to the Project Eagle portfolio. Now, the December conference call was specifically, and it says this in the note, about an unsolicited bid, about the unsolicited bid from PIMCO, in order that the Finance Minister could brief the First Minister and yourself. Were you aware of that conference call at that time, prior to it?
No, I wasn't aware, and obviously since this has come into the public domain, and terms like the Deputy First Minister was fully briefed and fully engaged in the PIMCO bid, that is totally and absolutely misleading. And the reason it is misleading is because and we've all learned this since the controversy has arisen. In June 2013, the former Finance Minister, Sammy Wilson, wrote to Michael Noonan re-investor interest in the portfolio, and Michael Noonan passed that letter to NAMA. I wasn't aware of that.
On the 27th of September 2013, there was a meeting between the First Minister, Minister of Finance and Personnel Simon Hamilton, and Michael Noonan at Stormont. I wasn't aware of that. On the 25th of March 2014, there was a meeting between the First Minister, Finance Minister Simon Hamilton, Ian Coulter and Cerebus Chair Dan Quayle and a delegation at Stormont Castle. I wasn't aware of that. On the 3rd of April 2014, Simon Hamilton asked NAMA to call the First Minister, to let him know that the sale had been agreed. The DUP party issued a press statement on the First Minister's name welcoming the sale. So there was no statement from the Office of First and Deputy First Minister welcoming the sale, and NAMA didn't call me. So for anybody to suggest that I was fully briefed and fully engaged in any of this is totally and absolutely wrong.
But just to clarify again, given how OFM is supposed to function in your view, and given that the First Minister, it appears, was operating in his capacity as First Minister, you should have been kept fully up to speed with all of these meetings and engagements where Mr Robinson was acting as First Minister.
Well, it raises very serious questions in relation to what capacity the First Minister was acting, because if I wasn't aware of these engagements taking place, then it clearly suggests that the First Minister was in concert with the Minister of Finance and Personnel, who was from the DUP party, was involved in an enterprise which also involved Michael Noonan without my knowledge in terms of the meetings that were taking place. Now, that raises questions about how Michael Noonan, the Minister of Finance in the South, was handling this situation. The only conversation that I had with Michael Noonan was on the 14th of January 2014, when the First Minister and I were involved in a conference call with Michael Noonan. So outside of that, it was quite clear that there were all sorts of other meetings taking place that I was unaware of. And I say that in the context of the issues that have been raised now in the course of this conversation. And I say that without even entering onto the ground of the allegations that have come from a TD in the South in relation to other allegations that he's making, of which I have no knowledge.
Okay, Deputy Chair.
Thanks very much. Morning, Deputy First Minister.
Morning, Dominic.
Welcome to the committee. Can I just go back to the two Northern Ireland, the two people who were appointed to the Northern Ireland Committee of NAMA, Mr Cushnahan and
Mr Rowntree.
Mr Rowntree. Were you given the opportunity to express your views on those appointments?
There was no OFM, DFM involvement in the individuals appointed. That was an appointment made by the Department of Finance and Personnel. Naturally, we were aware of the intention to appoint Northern advisors, but in terms of OFM, DFM having a role in it, we had no role.
And I mean, considering the reason that was given for requiring these appointees, that it was important to protect the Northern Ireland economy, that there was a danger of a fire sale of NAMA assets, and that would impact in a very negative way on the economy here. Would the issue not have been of sufficient importance to be raised at an executive meeting?
Well, I think at the time no one considered that to be of a major issue at the time. Absolutely agree with you in relation to the concerns that we as an executive had in relation to the prospect that there could be a fire sale. Now, remember, the appointment of these two people predates the controversy that we're presently embroiled in relation to all of this. And I remember on quite a number of occasions that in doing radio and television interviews, both myself and the First Minister legitimately raised our concerns in relation to how NAMA would handle the northern portfolio in relation to the prospect that there would be a fire sale which could act detrimentally to businesses in the north and ultimately be very damaging to our economy.
Yeah, you know, I agree with you that the appointments predated the present controversy, but you know, the point I was making is that the whole thing was of such importance to the economy that, you know, one would think that perhaps the Finance Minister would have brought it to the Executive and brought the appointments to the Executive, but that didn't happen. So
well, that didn't happen, and to be fair, I don't think at that time that it was necessary, because even at meetings of the North-South Ministerial Council, which were attended by most of the ministers on the Executive, the First Minister and I, on a consistent basis, raised our concerns around fire sale, and Michael Noonan responded at those meetings to our concerns. So there was nobody on the Executive in any way discomforted by the fact that it wasn't endorsed by the Executive, given that the responsibility for making the appointments rested with the Department of Finance and Personnel, and there was no objection raised at the time by anybody.
okay, but you're saying that there wasn't the opportunity to raise any objections because it didn't come to the Executive?
No, it didn't come to the Executive, but I'm sure that if people wanted to raise it as an issue of concern, they would have raised it under any other business at the Executive, and nobody did.
Okay. So, and what you've said to the Chair there, there's obviously a conflict of information about the paper trail you mentioned earlier on. You say it doesn't exist, that there isn't the paper trail within your department to support what the First Minister said, that you were aware of certain issues.
Well, the office is a joint office, and my officials, who are very diligent in the work that they do, were very thorough in relation to responding to what was said in that regard, and they have informed me that there is no paper trail. If there is something else out there that I'm not aware of, then we await to hear about it.
But is this not a very serious situation where the First Minister is claiming that you were aware of these issues and is claiming that there is a paper trail there to support his assertions, and you're saying that the paper trail doesn't actually exist and that you have made efforts to track down the paper, and your officials have diligently searched and found nothing? I mean, one would have to come to the conclusion that the First Minister is telling lies about this issue.
Well, I'm not accusing the First Minister of telling lies. What I'm saying very clearly is that the Office of First and Deputy First Minister is supposed to be a joint office. Officials in my department were tasked to establish whether or not there was a paper trail after this was said, and they have told me as a result of their searches that there is no paper trail. If people have evidence of a paper trail, then like everybody else, I would be interested to see it.
But if the paper trail doesn't exist, what other conclusion can one come to about the First Minister's assertion?
Well, I think you have to come to your own conclusions. I am here outlining my response to what has come into the public domain in the course of recent times, which has been specifically around the telephone conversations between the former Finance Minister Simon Hamilton and representatives of NAMA, which suggested that I was fully briefed and fully engaged in the, I presume, the PIMCO and ultimately the Cerebus deal. And I have outlined, for the benefit of this committee, and I can repeat it, that I do think it is of huge significance that in June 2013, the former Finance Minister, Sammy Wilson, wrote to the Finance Minister in the South, and I was never made aware of that, that a meeting took place in Stormont between the Finance Minister from the South and Simon Hamilton, our Finance Minister, and the First Minister, which I wasn't aware of. I had not been informed or involved in that meeting. And again, on the 25th of March 2014, it has since emerged that the First Minister, the former Finance Minister, Simon Hamilton, and Ian Coulter met Cerebus Chair Dan Quayle and a delegation at Stormont Castle. And I have to say, I think that's hugely significant, because for a man who was the former Vice President of the United States to have visited Stormont and to have met with the First Minister, but without my knowledge, certainly doesn't suggest that I was fully briefed or fully engaged in any of this. And then, of course, on the 3rd of April, not long after that, the former Finance Minister asked NAMA to call the First Minister, not the Deputy First Minister and the First Minister, to call the First Minister to let him know of the sale. And then the DUP party went on to issue a press statement in the First Minister's name welcoming the sale. So I think that makes it clear.
Well, what was
any suggestion that I was fully engaged or fully briefed?
What was your feeling or your reaction when you heard that announcement?
I was gobsmacked. I was gobsmacked when I learned in the aftermath of the contributions that came in the Dáil and the information that then flowed from all of that from different sources, that a former Vice President of the United States in March 2014 was in Stormont, meeting with the Finance Minister and the First Minister and others, without my knowledge.
Well, it would seem then that, well, maybe to say that you had the wool pulled over your eyes would be too strong, but you certainly were, according to your evidence, kept in the dark about these issues. Would that be a fair assessment?
Well, I had no knowledge of these meetings, so if I wasn't being told that these meetings were taking place, I was certainly kept in the dark.
And what are the implications of that for the relationship between yourself and the First Minister?
Well, I mean, it does raise very serious questions about the approach to the running of the office of First and Deputy First Minister. And one of the difficulties that we have in the issue of running the office of the First and Deputy First Minister is that it is possible for a department under the stewardship of the DUP to deal with an issue and for the First Minister to be present there. But it's very important to state that when he is there, without my knowledge, that he's not there as First Minister of these institutions. He's there as leader of the DUP. And this hasn't been the first occasion when this happened. I'm sure people are aware that there were other situations. But I certainly think that there is a blurred line there in relation to who people think they're representing when they attend meetings of... I mean, for example, if one of the ministers under my stewardship and the executive was involved in an issue and I was called into it, I would consider myself to be there on the basis of being the leading Sinn Féin representative in the institutions, and would only consider myself to be there as First Minister, as long as as Deputy First Minister, as long as the First Minister and his side of the department were aware of it and consented to it.
And do you intend to take any action, in light of the fact that you were kept in the dark?
Well, without opening this debate into a bigger debate, there's no one around this table not aware of the present negotiations which are taking place. And during the course of a number of contributions that I've made in recent weeks, I've raised the issue of future working relationships. And of course the media major on working relationships and do so mostly in a fairly negative way. But it's more widespread than just how we operate the Office of First and Deputy First Minister. There are other issues, but I mean, that's not for this committee and it's not part of the ongoing discussions which you are charged to deliberate on at this time. That's something for us to deal with outside of this arena.
Yeah, I agree with you that it possibly would go outside the terms of reference here. But considering the public interest there is around this particular issue, and considering the fact that there is a criminal investigation into it and a committee inquiry here, do you not feel that there's possibly the need for you to raise this issue specifically with the First Minister and the Minister of the former Minister of Finance?
Well, I am conscious, I'm very conscious that there isn't one potential criminal investigation but two, because we've learned in the course of recent times that the authorities in the United States are also looking at this situation. And obviously from that perspective, how this is dealt with in relation to the committee and what I say about all of that, I think I have to be measured and I have to be circumspect, consistent with giving total support to the investigations that are taking place. So I think that from my perspective, I want to deal with this in a mature way, consistent with ensuring that, and we haven't even touched on some of the more serious allegations that have been made, but obviously they deserve to be investigated, and the responsibility for conducting those investigations lies elsewhere, and I don't intend to say anything that would in any way compromise that work.
But just the point I'm making, and you reinforced it there, is that there are implications for the joint nature of the office of First Minister and Deputy First Minister, and as you said yourself, the investigations have now taken on almost a global aspect, and in relation to protecting the institutions here, do you not feel that perhaps you need to take further action?
Well, I think that's a bigger issue, but I don't think it's for discussion in the course of these deliberations today.
Why not?
Well, because I'm not here to discuss the ongoing negotiations that are taking place elsewhere on this estate, where these matters are effectively being dealt with. What I have outlined in the course of my contribution here this morning is a factual account of how I've responded to the assertions made in the telephone conversations between former Finance Minister Hamilton and Nama in regard to my knowledge of what was what was going on at the time. My knowledge of what was going on at the time was very scant indeed. I mean, the first I heard of this was whenever the First Minister told me that Michael Noonan had been in touch. And the big question really is, who was he in touch with? And it's obvious from what we have learned that the letter from Sammy Wilson in June of 2013 seems to have kick-started all of this, something that I wasn't aware of. But obviously, then, on foot of Michael Noonan being in touch with, for want of a better term, the DUP side of OFM, DFM. I was then told by Peter that there was an interest in the Northern portfolio by an organisation called PIMCO. I had never met PIMCO, I'd never heard of them, knew nothing about them. And the only other information that I was given was when I was told that the PIMCO approach had collapsed and there was no explanation. I assumed it was a lack of interest on their part for whatever reason. And of course we have now heard very serious allegations being made in that regard. I was aware of none of that.
No, the point I was making within the terms of reference of this committee, you stated that there was information exchanged between the Minister of Finance and the First Minister, which was not shared with you. And this committee, part of its remit is to hold the Minister of Finance to account. And it seems that the sharing of that information could be said to have been undermining the joint nature of the office of First and Deputy First Minister.
Well, I mean, I just repeat what I said earlier. For me, anyway, the most serious aspect of all of this in relation to the jointry is the fact that on the 25th of March 2014, it appears a meeting did take place in Stormont between the First Minister, former Finance Minister Simon Hamilton, and Ian Coulter with Cerebus, and the former Vice President of the United States, Dan Quayle, and the Chair of Cerebus. And I wasn't made aware of that. So that I do regard as very serious indeed. The only time I met Dan Quayle was 6 months after the sale was agreed between NAMA and Cerebus. And in fact, one of the local newspapers, in the aftermath of the controversy, described that as a secret meeting. There was nothing secret about it. I actually tweeted out a photograph on the day of Peter Robinson and myself with Dan Quayle. Absolutely nothing secret about it.
Yeah, but
Dominic, just bring a conclusion if you're quick.
I'll emphasise once again, the fact that you weren't aware of a very important meeting which took place and which had sort of international aspects to it. One would have to say that your position as Deputy First Minister was undermined by that.
Well, that's a view that you are entitled to hold.
But you don't share it?
No, I think that my position as Deputy First Minister, I have rigorously stood by the rules of the office and have never, in the course of the 8 years that I've been Deputy First Minister, hopefully I've never done anything that in any way undermined the integrity of the office. Obviously there are questions now being asked about how the situation developed since the original letter from the former Finance Minister Sammy Wilson in June 2013 through to the, I suppose, the allegations that were offered up in the Dáil just a few months ago. And it's obviously our job to deal with the implications of all of that, and we will deal with those implications.
Thank you.
Okay, thank you, Deputy Chair. John?
Thank you, Chair. You're very welcome, Deputy First Minister. I suppose just briefly to touch on your not-so-secret meeting with former US Vice President Dan Quayle and the First Minister. I take it this wasn't discussed at that meeting, the NAMA, the sale, or anything when you did meet with him?
Well, the fact that there was a meeting took place on, let's get the date right, on the 25th of March 2014. That wasn't discussed at that meeting. I only became aware of that meeting in the aftermath of the allegations that were made from Dublin.
Yeah, so that wasn't discussed at your...
Nobody mentioned it.
No.
Nobody mentioned the fact that a meeting had taken place earlier in the year.
Or the whole NAMA sale, or
It was basically, the meeting on in September was basically a courtesy visit, 6 months after the sale had been completed. And remember, the issue of the sale of the Northern portfolio was absolutely and totally under the control of the Irish government and NAMA and the people who bought the portfolio. So my ability as Deputy First Minister to impact on all of that, and indeed it could be said the First Minister's ability to impact on that, was fairly limited.
Thank you just for the clarification on that. I think it's important. I do find it remarkable that you would have somebody like Dan Quayle in Stormont Castle with the First Minister and with the former Finance Minister and not to be informed. I share the concerns around, it's no secret that I think a more appropriate name for the office you hold is the office of the First Minister. And it should and it's meant to function co-equal, co-joined, whatever. And I do think it damages the office when things like this happen. Bear in mind, you've been Deputy First Minister right from the 8th of May 2007. So right through, you mentioned various contacts with, say, Minister Noonan. Obviously before Michael Noonan became Finance Minister, a different administration, the late Brian Linehan was Minister of Finance for a period of time. Some of these early appointments or suggestions to the Northern Ireland NAMA Advisory Board were made during that time. There was also a senior civil servant was suggested by DFP at that time. Would that not have, Richard Bengelly, would that not have merited discussion with you because of the nature of even nominating? I know my understanding from earlier was that the Finance Department in Dublin said no, it wasn't appropriate for him, but because they were nominating a senior civil servant from Northern Ireland, would that not have automatically merited it being discussed by at the very least the First and Deputy First Ministers with the then Finance Minister?
I remember this was something like 5 years ago. This controversy has only arisen in the course of recent months. So there was never any question marks over people having objections to the appointment of Frank Cushnahan or Brian Rowntree as advisors. In fact, I think generally at the time we would have thought that that was a good thing in relation to the concerns that we have or had at the time around the prospect that NAMA would be involved in a fire sale that would be detrimental to businesses in the north and to our economy.
Well, and entirely, Chair, take the point about the fire sale. There was some suggestion in earlier evidence about who nominated Brian Rowntree. Was it another minister within the executive, or was it the Finance Minister? Have you any knowledge on who?
Well, I worked on the basis that the nominations for the two people came from the Finance Minister.
And not from any other minister within the...
Well, I mean, I haven't got an exact recollection of that, but I think that the responsible department nominating the two individuals was the Department of Finance and Personnel. If other people made suggestions, and sometimes that does happen, it's not relevant. What is relevant is who was appointed at the time, and I think it's fair to say that those appointments were not controversial.
Thank you, Chair. Thank you,
Kayla?
Thank you, Chair. You're very welcome, Deputy First Minister. I suppose my question's following on from the Deputy Chair. In your opinion, why do you believe you were kept out of the loop in relation to the matters? And do you believe this to be deliberate or otherwise? And if so, to whose benefit?
Well, I mean, I think that that is ground I should not go on to. I think the purpose of me coming here today was to deal specifically with what was put into the public domain in relation to myself in the course of recent times. At the end of the day, all I can do is provide, as best I can, a factual account of the situation as it pertains to myself. And I think at the end of the day, other people can draw their own conclusions from it. And when I say that, I'm not casting any aspersions on anybody at all. What I have outlined as honestly as I can is my repudiation of the suggestion that I was briefed or fully engaged in these encounters. Nothing could be further from the truth. How people read that, I think I leave to the court of public opinion, and also to the opinion of my colleagues here at this investigation.
Deputy First Minister, also since the First Minister muted that you were kept briefed of the matters, have you, if you're at liberty to say, have you engaged with the First Minister since he muted that? Have you had a conversation with him?
Well, since the allegations were made in the Dáil by a TD, the situation has become very serious indeed, with a criminal investigation taking place and reports that another in America is due to take place. This inquiry was established very quickly by the chair of the Finance and Personnel Committee, and I think that in those circumstances I leave it to the investigations to deal with these matters.
Thank you. Chair.
Adrian?
Thanks, Chair. I'll be pretty brief. Just go back to your point, Deputy First Minister, whenever you said that you were told that the Pintco deal had collapsed. Did you not ask any reasons why it collapsed or anything else? You just said, fair enough, First Minister, that's it. Or did you ask around why it collapsed or get any information at that time?
No, I didn't ask, because this was something over which I had no control or no say in.
Yeah, but we're not interested in it, you know, to know.
No, I just thought that they withdrew their interest in the portfolio for their own reasons. I didn't seek answers
Well,
to those questions.
that surprises me, Chair, because, you know, it's a big deal, something very important to Northern Ireland, and the Deputy First Minister didn't ask any questions about it. Just, I'm surprised at that there. But moving on, did you ever meet the TD who made these announcements, either before he made the announcements or after he made the announcement in the Dáil?
I have never met Mick Wallace.
Fair enough,
The closest I ever came to Mick Wallace was during the course of the presidential campaign in 2011. I was canvassing in his constituency, and he was coming out of a school as I was going in, and I recall he didn't even say hello.
Martin?
Margie Moy, Deputy First Minister, good to see you. Just to remind ourselves what we're talking about, you know, 850 separate loans, 55 developers, loans over €5 billion, finally sold a service for around £1.2 billion. So somebody did very well out of this. and the person carrying the can is the ordinary working Joe and Josephine in the south of Ireland, who have to make up the difference in the loss to the taxpayer and to NAMA of the sale. And that's bad enough, but for people to find then that there's corruption at the heart of this, there's fraud at the heart of this, and embezzlement is what brings us here today. And you've told us you had no knowledge of the comings and goings in relation to the prospective buyers, but I suppose what people would like to know is that if you had known that the Finance Minister in June 2013, Sammy Wilson, received a letter from Brown Rudnick saying that they had a buyer who would only buy the NAMA portfolio in a private deal, and he passed that letter on the same day. If you had known that the Finance Minister here was facilitating a closed bid for the NAMA portfolio, would you have set the alarm bells ringing?
Well, I mean, the record of all of this shows that I wasn't aware. If I had been aware, then I think we would have been much more inquisitive about what was happening. But the only knowledge that I had at the beginning of all of this was that word had come from Michael Noonan that there was interest in the Northern portfolio. That was the height of it, and that was followed up obviously by our continual expressions of concern around the prospect of fire sales and how it would impact on our economy. And essentially, you know, the information that has come into the public domain since is obviously something that is subject to both a criminal and a political investigation in relation to the work of this committee. Would
it have been helpful if Mr Noonan, because our former Finance Minister, Mr Wilson, Sammy Wilson, wrote to Michael Noonan with this offer, would it have been helpful if Mr Noonan had have communicated that to the government here, communicated that to you, that this project was being facilitated? Or?
Well, I mean, it goes back to the question asked by the member earlier. I would have thought if there was question marks over the collapse of the PIMCO effort to acquire the portfolio, that there was a responsibility on the Finance Minister in the South, who knew much more about this than I did, to inform officially the office of the First and Deputy First Minister. That didn't happen. There wasn't anything, and I've been told that PIMCO had withdrew their interest at that time to raise concerns in my head that there was something untoward taking place.
And to bring the PIMCO story on, in March 2014, Minister Noonan is aware that PIMCO were withdrawing because they were told they had to pay a kickback of £5 million to Frank Cushnan, who's on the NI NAMA Advisory Board. Mr Noonan knew that, NAMA knew that. If you had have known at that stage that PIMCO had withdrawn because of their concern, their alarm at a fraudulent payment, would you have intervened to stop this dirty scheme?
Well, if we had have known what has been alleged now, and that is also important to say subject to investigation, and I don't think that I can preempt the outcome of that investigation and the very serious allegations that are being made. I mean, it is important to point out that Frank Cushnan had actually stepped down from the NAMA Advisory Committee in November 2013. So these are matters that are the subject of criminal investigations, and I think that it should be left at that. But I do think that, you know, some of the allegations that have been made, if the office of the First and Deputy First Minister had been officially aware of all of that, it would have been a very serious matter indeed.
Just to finish, Chair, the final meeting in Stormont Castle, I believe, with the former Vice President Quayle and the other players, it seems to me, Chair, that would have been a fairly impressive lineup for the Chair of Cerberus to be brought in to Belfast to meet with the most senior politician in his shoe in this jurisdiction, to meet with the Finance Minister and to meet then with Mr Coulter and Mr Cushnan. That's just before the deal was sealed. And I leave it like that. I am amazed that a meeting of that import and so important would happen without the Deputy First Minister being informed. So
well, it's particularly surprising that the individual that you mentioned, Ian Coulter, was present at that engagement, and I wasn't.
Just a brief supplementary to that, Martin, and just to sum it up. I mean, is it fair to say then that the Department of Finance in Dublin and Minister Noonan failed to respect your position as Deputy First Minister? And going on what Martin has said, if you had been kept up to speed, things could have turned out very differently indeed.
Well, I have written to the Finance Minister outlining my view that the Minister of Finance did not respect the office of First and Deputy First Minister. And I think the Taoiseach is also aware of my strong view that that was the case. So that is disturbing. But what I find almost incomprehensible is that the people who are aware of the circumstances of the withdrawal of PIMCO from interest in the Northern Portfolio and the circumstances around it, i.e. NAMA, the Finance Minister, but particularly the Finance Minister, did not officially inform the Office of First and Deputy First Minister, and it raises questions. And I'm not making any allegations. Was there a partial sharing of that information? And if so, why was that the case?
Okay, Paul.
Thank you very much, and thank you, Deputy First Minister. I want to really go back to the point where there seems to be some indication of that you were being kept out of the loop, and whether that is perceived or reality is a point. And it's to see whether the recollection of the timeline of things have who would be the person that would have been communicated from in your department from the First Minister's office. Would Dara O'Hagan be the person who would receive communication on that, to that effect, or would it be directly to yourself?
Oh, well, I mean, our advisors meet regularly with First Minister's advisors, the Principal Private Secretary and different officials within the Office of First and Deputy First Minister have regular contact, work in very close proximity. But, I mean, I come back to the meeting of the 25th of March, which was attended by the First Minister, Simon Hamilton and Ian Coulter in Stormont. I was in Belfast that day, met with the First Minister, and I just find it incredible that the First Minister didn't tell me that a former Vice President of the United States was in Stormont Castle earlier that day.
Yeah.
Can't get my head around that.
The point I want to maybe go through to is right to the very start, and we'll go back maybe into 2013, where Simon Hamilton's statement, which was made in December of 2013. Do you believe that was inaccurate in the way that it was presented? In that he believed the First Minister and Deputy First Minister were aware of the PIMCO transactions and negotiations at that stage. Was he misleading, or was he believing or giving out factual information?
Well, I was aware because the First Minister told me that an organisation called PIMCO were interested and were seriously considering purchasing the Northern portfolio. But that was the height of it, and I was told that because that information was given to me by the First Minister on foot of information that he had from Michael Noonan, the Finance Minister in the South. Now, in all probability, and I'm not certain about this, that information came from Michael Noonan via the Department of Finance and Personnel to the First Minister, or directly from Michael Noonan to the First Minister. I don't know the answer to that, but I do think, given that the two finance departments were involved in this, going back to the involvement of the previous Finance Minister, Samuel Wilson, in the early part of 2013, it's quite clear that conversations were taking place, but that I was, I'm trying to be fair in all of this. I was only being given partial information.
I appreciate that we're dealing with 2013. It's back a fair wee while. June was mentioned as a first contact in relation to the PEMCO issue coming through in June. Suffice to say, in September of 2013, there was a meeting between the First Minister and Michael Noonan in Stormont. Were you aware of that meeting?
No. But it wasn't just a meeting between the First Minister and Michael Noonan.
I appreciate it was to do with...
The Finance Minister was also there.
Yes, but that was in September of 27th of September 2013.
Yeah.
And you say you weren't aware of that. Okay. Were you briefed by the First Minister about the PEMCO deal at that time, or any time after that?
What do you mean by briefed by him about the PEMCO deal?
Informed.
No, all I was told about
that would have been.
All I was told by the First Minister was that, on foot of information that came from Dublin, that there was an interest from PEMCO in the Northern portfolio, and that was like courtesy information being supplied to you, because the ultimate decisions on all of these matters were going to be taken by the Irish government.
And when were you told about that?
When was I told?
When were you informed about that aspect?
It was probably a few weeks prior to the conference call that the First Minister and I did with Michael Noonan, which I think was in
2014.
The 14th of January 2014.
2014. So, according to that nothing would have happened. Were you aware of a proposed memorandum of understanding, which was sent to by the First Minister, Principal Private Secretary at that time?
Well, I mean, you've just said it yourself.
Were you aware?
You've described it as a memorandum of understanding.
Yes.
From the First Minister and the Principal Private Secretary of the First Minister.
Were you aware of it?
I didn't know, and I didn't consent to it, and my Principal Private Secretary didn't consent to it. For that to have been a valid communication from the Office of First and Deputy First Minister to the Finance Minister in Dublin, it would have required my consent, or on my behalf, the consent of my Principal Private Secretary. None of the two happened.
Okay. And I want to move on to, so the issue of the bid for the NAMA Northern Ireland portfolio, was it ever discussed at an executive level?
The bid itself, no. No.
Earlier I asked you about a meeting that took place on the 27th of September 2013, and you stated that you weren't aware of that. I'm just going to try and bring something. Appreciate that some information might well be available here that maybe you don't have to hand as well. Would I suggest that you're aware that the meeting, in fact, you were invited to it, and I would suggest that the First Minister discussed with you the proposed approach to NAMA in advance of that meeting. And I'm just stating, is it possible to suggest that you were invited to that meeting?
No, I was not informed or involved in any way in that meeting.
Okay. Are you aware of a text message stating that you would be unable to attend because you were going to be in attendance at a funeral on that day?
A text message from me?
Well, from either from yourself or somebody within DFM.
Well, I sent no text message and I'm not aware of that.
Basically, I'll come back it later on with other members.
Okay, Jim?
Mr McGuinness, who's Darragh O'Hagan?
Who is Darragh O'Hagan?
Who's Darragh O'Hagan?
Darragh O'Hagan was an advisor in the Office of First and Deputy First Minister.
If it's Mrs O'Hagan, isn't it? If Mrs O'Hagan...
No, it's Miss O'Hagan.
Miss O'Hagan. If Miss O'Hagan, was she your senior advisor at that time?
Well, all our advisors are of equal seniority.
Yeah. But she would be a very experienced advisor.
Well, she's been in the department for a number of years, yeah. She's now moved on to another department.
Now, if Ms O'Hagan received a document, an important document, in her role as a SPAD, would it be normal for her to pass that to you? Would that be the normal protocol?
Only if it was for my attention. If it was thought on her judgment, something that I needed to pursue.
Is this the same Ms O'Hagan, the former MLA?
Yeah.
Right.
I think you're well aware of that.
Yeah. Just want to establish, not the whole community, Mr McGuinness, just I want to establish the fact this is a former MLA we're dealing with. So someone with a considerable legal nonce and understanding. Now, I have here before me a email from David McCready of OFM DFM to Darragh O'Hagan, dated the 19th of December 2013. Are you aware of that memo?
No.
Right. Well, that email states NAMA document as discussed, and that's in reference to the Memorandum of Understanding dated December 2013 from Bravo Strategies, which of course we know who Bravo Strategies are. With the Memorandum of Understanding, I have it in my hand here, the document. That was attached to that email to Darragh O'Hagan. Are you telling me that Darragh O'Hagan did not make you aware of the existence of that Memorandum of Understanding?
If Darragh O'Hagan, and I don't know the veracity of what you're saying, but if we work on the basis that what you're saying is the case, if Darragh O'Hagan made a judgment in her mind as a senior advisor within the Office of First and Deputy First Minister that I should not be involved in that,
but an issue that
it would not come to me.
An issue that expressed concern about, an issue that she knew was... I mean, we're talking about a £1.25 billion transaction here, £5 billion of worth of assets, the largest property holder in Europe, and a company that holds a high percentage of all the property in Northern Ireland. You're saying that Darragh O'Hagan, a former MLA and a senior advisor, decided that it's not for your attention?
Yeah, if she thought that she was sufficiently concerned that this was something that I, as Deputy First Minister, should not be associated with, perfectly legitimate for her to do that. Advisors do that all the time.
Of course.
As yourself as a former Health Minister would know.
Can I assure you that any of the SPADs in the Health Department had failed to provide me details of a document involving £5 billion, heads would have rolled. We're talking £5 billion of assets in Northern Ireland, and you're saying that that was never passed to you and you've no knowledge of it?
I have absolutely no knowledge of it. All of what I've learned since that it was sent from one side of OFM DFM to Dublin without the consent of myself and my principal private secretary. And look at it another way. You would think that if people thought that that was something that we would have signed up for, that they would have come to me at a very senior level, i.e. the First Minister would have come to me and said, there's a memorandum of understanding which I want to send to Dublin, I want you to agree with. Never happened.
I put it to you, Deputy First Minister, in fact, that document was discussed with you before it was sent to Ms O'Hagan.
Not true.
Right. Okay. Are you aware, first of all, can you tell me, do you know who Mr Declan Reid is?
Who?
Mr Declan Reid.
No.
Are you aware who Mary Lou MacDonald is?
I am, yeah.
Could you maybe, for the record, tell me who Mary Lou MacDonald is? Not everybody in Northern Ireland may know who this lady is.
Mary Lou MacDonald is a TD, a Sinn Féin TD, in Leinster House, represents Dublin Central.
Right. So, are you aware that there was a conference call held on the 14th of January 2014 with Mr. Peter Robinson and Michael Noonan?
Yeah, I've already explained that.
And you're aware that the Memorandum of Understanding was discussed at that call, and it was agreed that a draft would be forwarded to NAMA?
No,
You don't recall that at all?
no.
Yet the evidence from Declan Reid, and this Declan Reid, of course, I asked you earlier, you don't know who Mr. Declan Reid is from the Irish Department of Finance. That's the Irish Public's Department of Finance. Gave evidence to the PAC, that's the Irish Parliament, Irish Public Accounts Committee, as opposed to the Northern Ireland Public Accounts Committee. This letter confirms that the origins of the letter in relation to the MOU was sent to the First Minister's principal private secretary. Is that wrong?
Say that again.
That Declan Reid, who we established, is works for the Irish Department of Finance. He gave evidence to the Public Accounts Committee in the Republic on the 9th of July this year, that's 2015, which confirms the origins of a letter in relation to the MOU that was sent by the First Minister's principal private secretary. Are you aware of that?
Well, I am aware that the First Minister, Principal Private Secretary, sent a Memorandum of Understanding to the Irish Government, and that it was sent without my consent, and without the consent of anybody in officialdom within my side of OFM-DFM. So it had no validity whatsoever.
Well, could I just read you an email from Declan Reid? I wish to clarify the matter for Deputy Mary Lou MacDonald. This is Mary Lou MacDonald from Sinn Féin. The Memorandum of Understanding originated from a call between Ronnie Hanna, the First Minister, the Minister, Minister Robinson's office and me regarding the sale process. Minister Robinson indicated that he had concerns about how NAMA or any owner of Northern Ireland loans would manage these loans in the interests of the Northern Ireland economy, which was understandable. He indicated that he would seek to put such a letter of intent or MOU in place with potential bidders. We advised him that it would be wise to send it to NAMA for its information and identified Ronnie as the appropriate person to send this. Mrs. MacDonald, Miss MacDonald, presumably was then informed of that.
Well, what you've just outlined is what you say is a communication between an Irish government official and the First Minister.
No, well, at the office of the First Minister.
Well, but hold on a minute. Hold on a minute. Who in the office of the First Minister was he communicating with? Because he wasn't communicating with me, and he was not communicating with any of my principal private secretaries.
He's communicating with Mary Lou MacDonald.
Mary Lou MacDonald had absolutely nothing to do with the Memorandum of Understanding.
Yes, but so you do contact with Mary Lou MacDonald about this?
Is this in her capacity as a member of the Public Accounts Committee? Just for clarity.
Well, Mary Lou MacDonald is a member of the PAC in the Irish Republic.
Yeah, but is it arising from the PAC meeting?
The PAC were investigating this issue. And this is the Irish PAC was investigating this issue.
Yeah, but what you have outlined in the course of your contribution over the course of the last couple of minutes confirms what I'm saying, that there was contact between Irish government officials and the DUP side of OFM-DFM. I am saying that that person, I think the name you mentioned was Hannah?
Declan Reid is the official.
No, you mentioned another official.
Declan Reid is the banking division of the Department of Finance.
Yeah. But who did you say was in contact with the office?
The name is Hannah.
Yes.
It's Ronnie Hanna.
Yeah. Well, what I can tell you, and I'm open to contradiction in this, is that I have no knowledge whatsoever of Mr. Hanna being in communication with anybody on the Sinn Féin side of OFM-DFM.
Right. There was a press coverage in the Irish News, and you issued a statement, well, the Sinn Féin issued a statement which says as follows: Mr McGuinness refutes any claim that he was fully briefed and engaged with the proposed sale and subsequent collapse of the NAMA North, I presume the Northern Loan refers to the Northern Ireland Loan Book, to PIMCO, as suggested to NAMA by the former Minister Hamilton, a Sinn Féin spokesman said. Is that still your position?
I have outlined graphically on 2 occasions during the course of my contribution to this committee the individual circumstances that clearly prove that I was not fully briefed or fully engaged in either the PIMCO or the Cerebus deal.
Right. Do you recall...
I could do it again for your information if you want.
Do you recall a conference call which was held on the 14th of January 2014? Do you recall a conference call between you, Mr Robinson, and Mr Noonan?
I've already mentioned it during the course of this hearing.
And do you accept that during that the issue of the MOU was discussed?
No, I don't. It may have been mentioned by the finance minister in the south, but one thing is for sure, and that is the memorandum of understanding that was sent from the DUP side of OFM DFM to the Irish government did not have my consent, my support, or any official or advisor within my department.
You suggested that the First Minister never discussed the MOU with PIMCO with you. You never saw it and were never aware of such a...
No, I never saw it, and I think that it is significant. And I think you're obviously turning a blind eye to what I'm saying. That whenever that communication was sent to Dublin, it was sent from the DUP side of OFM DFM and did not have the consent of myself as Deputy First Minister or any official in my department.
But going back to Mr Gervin's questions, in December 2013, Simon Hamilton told NAMA that you'd been briefed. He actually told the National Asset Management Authority that you had been briefed.
Yeah, and I've responded to that.
And you're saying that's not true.
Well, do you want me to take you through all of the examples of which blow out of the water the contention that I was briefed or fully engaged
but why would
in this
Mr
process?
Hamilton lie?
Well, I'm not accusing anybody of lying. What I'm saying is that we clearly have in the public domain the remarks made by former Minister Hamilton. And people now have, because of my testimony to this committee, my refutal of the assertion that I was fully briefed or fully engaged in the process, and I will take you through it again. I find it inconceivable that the former Finance Minister, Sammy Wilson, wrote to Michael Noonan, and I had, as Deputy First Minister, no knowledge or involvement in that correspondence. And of course, on the 27th of September, I was not informed or involved in a meeting with Michael Noonan. On the 25th of March, we had Simon Hamilton, First Minister, Ian Coulter, meeting with a former Vice President of the United States, Dan Quayle, and a delegation at Stormont Castle. I wasn't there, I didn't attend, and there's no record of me having been informed or invited to the meeting. And of course, and you've mentioned the communications between former Minister Hamilton and NAMA, but on the 3rd of April, in relation to that conversation, NAMA's note of the phone call to Simon Hamilton to inform him of the sale was agreed to Cerebus. Simon Hamilton asked NAMA to call the First Minister and to let him know about the sale. So Simon Hamilton didn't say, call the First Minister and the Deputy First Minister.
Because the First Minister then spoke to you.
I was excluded. I was excluded. The office is a joint office, and as you well know, First Minister has no more authority than I have. I have no more authority than he has. We have co-equal responsibilities. But further to that, in the aftermath of being informed that the sale had gone through, the Democratic Unionist Party issued a statement in the First Minister's name, welcoming it. So it wasn't that the First Minister's publicity people came to the Sinn Féin side of OFM-DFM and said there should be a joint statement from the First Minister and the Deputy First Minister. That didn't happen.
But the First Minister spoke to you and then followed up that conversation with email from David McCready, and also you had at that stage received the Memorandum of Understanding. Now, if you'd received the Memorandum of Understanding, you knew full well what was going on.
I never saw any Memorandum of Understanding, and the Memorandum of Understanding that was communicated from the First Minister's side of OFM-DFM to the Irish Government had no validity whatsoever because I had not consented to it.
I suggest, Mr McGuinness, you go back to Ms O'Hagan and you check did she receive that, and check did she then pass it on to you, because if she did, that document is so explicit that no one could claim that they didn't know exactly what was going on with the assets in Northern Ireland. That document runs through 4 pages of close printed text, which gives chapter and verse on everything that was going on, and we know for certain that this email was attached to this document and sent to one of your principal advisors, and you're expecting us to believe at no point in any of this discussion she did not make you aware of this document. Now, how did she subsequently make you aware of it in the last few weeks?
Well, the person that you speak about is a very experienced advisor, and if that did happen, and obviously I've made it quite clear in the course of this conversation that I never saw a Memorandum of Understanding, and that the Memorandum of Understanding that found its way to Dublin didn't have the consent of the Sinn Féin side of OFM-DFM. But given that the person that I speak about is a very experienced advisor, that person could have decided that the Memorandum of Understanding wasn't something that we could assent to.
Right. It would have been helpful, Mr McGuinness, actually, had you brought your dairy secretary here, because there seems to be a bit of confusion as to where you were and when. You suggested that the only meeting you had with Cerberus was in September 2014. But it's also the case that you were invited to the meeting with Cerberus in April 2014. Do you remember that?
April 2014?
10th of April 2014. Where were you on the 10th of April 2014?
Well,
I know where you are, but I'm hoping maybe you can let me know where you were.
Well, I don't know, and I have no recollection whatsoever.
But you should remember, because you were a very important person. You were dining with Her Majesty the Queen in Windsor Castle. Do you remember attending that event?
Oh, indeed I do.
Her Majesty, I'm sure, was delighted to see you, and I'm sure the people of Londonderry and Ulster were delighted to see you dining with Her Majesty in Windsor Castle.
I think she was much more delighted to see me than you are.
Well, not more delighted to see Her Majesty, they're never likely to be delighted to see you. So therefore,
Chair, sorry for
You're
cutting
annoyed
across
that you weren't invited.
No, I'm just annoyed that I don't see the relevance
Well, you will in a
this
minute.
under the terms of reference. So, you know, Mr. Wells, if you could.
but why that's significant, Deputy First Minister? And you do remember going to see Her Majesty. I think it was covered in the media, and there was some mention of it, right? And the reason that you couldn't go to that meeting on the 10th of April was because you were on a flight to London and didn't arrive in time for that meeting. Is that correct?
It's not correct, no.
So you weren't dining with Her Majesty?
I know nothing about a meeting with Cerberus on that date.
You don't know, so you don't believe that you were invited to a meeting on the 10th of April to discuss Cerberus?
Well, no. I mean, we can check it, but I certainly have no knowledge whatsoever of being invited to a meeting on that date.
Well, I think we have at least good documentary evidence of what happened on the 10th of April. And we can soon establish exactly where you were at that time. Could I say, Mr McGuinness, that...
Let me say this. I look forward to the so-called paper trail that people are talking about.
Yes.
You know, I haven't seen anything that even resembles it.
I think it's important, Chair, that I know Mr. Wells wishes to do this anyway. Voluminous correspondence he has there, no doubt that will be provided to the committee. And if there's another meeting that Cerberus, be interested to know who else was at that meeting in London, if it was in London or wherever it was. So, you know, let's all share the information and.
Just one point of clarity as well, Jim. I mean, is this OFM-DFM correspondence you're referring to?
It's correspondence that's dropped onto my lap, which has been helpful. Very helpful indeed.
It's been dropped onto your lap with somebody with a direct link to the terms of reference of the.
I think this is actually directly linked to the terms of reference.
Well, can I ask, was this a written invitation to me?
To dine with Her Majesty?
No, to meet with service.
Well, we can forward you the details, Mr McGuinness. I'm putting it to you that you were very well aware that there was a meeting on the 10th of April about this issue, but you were, and I do accept that your prior engagement was extremely important.
Can I ask who was at the meeting?
Well, Her Majesty and many representatives.
No, the service meeting. Don't be smart.
I have no intention.
Don't
I have no
smart,
intention of
Alec.
giving that information to you, Mr McGuinness.
Oh, well, why not?
I'm here to ask
I am giving you all the information
I asked
that I have at hand.
Give the evidence.
And you're sitting now talking about a meeting and you won't tell us who was at the meeting. We'd be very interested to know who was at that meeting.
Well, I can tell you this.
Because the First Minister was also in Windsor Castle.
Yes, he was,
Yeah.
quite rightly so.
So was he also at the service meeting?
Well, Mr McGuinness, I ask the questions, you do the answering. Secondly, I'm not here to assist your case. Now, finally, Mr McGuinness, it's quite clear what's going on here. That what you're doing is trying to distance yourself from a deal with the Dama deal. No, you didn't try to distance yourself at the time, but now that you see perhaps there's some controversy, you're frantically trying to roll back from decisions that you're fully aware of.
Well, it hasn't been much talked about in the course of our engagement here today, simply because we haven't got to the nub of why you're sitting here today investigating this. Only one or two, I think the member Martina Muller addressed the issues that people are really exercised about out there in the community. I don't think people out there in the community are in any way exercised about the evidence that I have given to this committee today. And I do think people are exercised about the very serious allegations that are being made and the names that have been mentioned. And very important to point out that the names that have been mentioned are no friends of mine. I repeat what I said. The individuals whose names are at the heart of this controversy and who do have a duty and a responsibility, and I am talking about Ian Coulter, I am talking about Frank Cushnahan, do have a responsibility to cooperate with police investigations, and do have a duty and a responsibility to cooperate with this committee. And I certainly am of the view that the people of which I speak are much closer to your party than they are to mine. So they're not friends of mine, they're not acquaintances of mine, and I have no worries whatsoever. But I think the people who should be worrying are the people who have explanations to give about what they were involved in, or allegedly involved in, during the course of both PIMCO and the Cerberus deals.
That wasn't your view, Mr McGuinness, when you met Cerberus, and you've admitted you met them.
If we met them as a courtesy of my duties and responsibility as Deputy First Minister, 6 months after the deal was agreed. And since that, we have had widespread allegations in the media, allegations which are being investigated, of corruption. And the people who are at the heart of that investigation are no friends of mine, they're not acquaintances of mine, and they're not friends or acquaintances of my party.
So your allegation is up to that point you've been kept almost totally in the dark, and yet you're perfectly happy to meet and greet and get your picture taken and issue a press release with the said Cerberus.
Well, you see, but the point that you're missing out on in all of this is that the allegations about possible criminality came after that, not before it.
But you're alleging that you were totally in the dark, and yet there you are standing smiling.
What you're ignoring is that the allegations of corruption and criminality that came into the public domain came after the September meeting.
I accept that.
Which was only a courtesy meeting.
Well, certainly if I'd been kept in the dark, I wouldn't be standing smiling for the cameras. Thank you.
I only found out afterwards that I was kept in the dark. I wasn't aware of it at that time.
So the whole deal was done, and you didn't ask yourself, well, I didn't know about this. Well, the reason is Mr McGuinness,
Well, you're ignoring the fact that all of this information about the meetings that were taking place, the personalities that were involved, has only come out after September 2014, and really only came out after Mike Wallace made a statement in Leinster House.
Sitting at your right-hand side in your office is Paul de Knowledge and Miss O'Hagan. Great, fine.
Leslie, thank you for your patience.
Thanks, Chair. And still good morning. Can I just return to the PAC meeting in Dublin on the 9th of July this year? The NAMA chairman gave evidence, and he referred to what he called a letter of interest dated the 17th of January 2014 from the Principal Private Secretary to the Northern Ireland First Minister relating to the proposed management of the Northern Ireland portfolio. And interesting enough, he then goes on to say the letter appeared to summarise an agreement between PIMCO and the Northern Ireland Executive. That in turn would lead to the MOU. That's surely, and I'm sure the chairman was right, is a very important statement to have been made. That there was such an agreement, I put that in inverted commas, made, and was supported by the Northern Ireland. That's a fairly serious thing if, as you say yourself, Deputy First Minister, you were unaware of that.
Well, there's no record of discussion with my office about sending the email or about bringing it to the executive. And don't ignore the reality that whenever the correspondence that was sent from the DUP side of the Office of First and Deputy First Minister that was sent to Dublin, it wasn't sent with my consent. And for it to be valid, it could only be a valid communication, given the nature of the joint office, if it was signed off on by Peter Robinson and myself, or by our principal private secretaries on our behalf. The fact that that didn't happen, I think, has to be a cause of concern.
And certainly
So the memorandum of understanding, so-called, wasn't worth the paper it was written on.
Because it didn't represent the views of the joint conjoined post.
That's correct.
Thank you.
Okay, last word, Ian.
Yeah, I suppose a number of colleagues have asked questions around this memorandum of understanding and whether or not you were or weren't involved or in any way. Just for clarity's sake, and I think it's important for clarity's sake, that the meeting that you were invited to on the 27th of September, that I think someone has referred to you not being available due to being at a funeral. Can you check if that was the case? If you don't have the details in front of you, can you check that that was the case, that you were at the funeral and that the DUP side of OFM DFM's office were informed of that as the reason why you couldn't attend?
Well, I have to check that.
So I'm grateful if you could check that. And in respect of the conference call, given the fact that the conference call took place, you said you were there, the memorandum of understanding was mentioned, did you not ask questions as to why or where or how this memorandum of understanding became available if you, as you say, weren't made aware of it prior to that conference call?
Well, I mean, in all of the communications that both the First Minister and I have had with the Irish Government, and specifically with Michael Noonan, we have consistently, and I've done this on the BBC, on interviews as well, majored on our concern about how a fire sale of businesses and land in the north would impact detrimentally on the economy here in the north. So, I mean, that was a subject of conversation during the conference call. The issue of the memorandum, so-called memorandum of understanding, and I know we're going round and roundabout here now. The reality is that what went to Dublin in the name of the Principal Private Secretary of the First Minister wasn't worth the paper it was written on, because I had not consented to it.
Yeah, but I'll accept that point, but the point that Jim Wells has made and made on a number of occasions is the fact that this document wasn't just sent, on a whim by the Principal Private Secretary to in the First Minister's office. This was discussed with you by the First Minister. It was discussed during a conference call. It was emailed following the conversation with the First Minister and you to your special advisor. Yet no one in the Sinn Féin side of the OFM-DFM office has any knowledge of any memorandum of understanding, or indeed your claim that you had no knowledge of it whatsoever, and that basically the First Minister told you what he felt you needed to know, not what you actually, I'd be surprised if the First Minister didn't say and go into more detail around what exactly the discussions that he had with the Southern Finance Ministers to inform you of the same. So I just find it hard. You keep referencing the stuff that's sent to the NAMA or from the First Minister's side of things, but you don't reference anything of the fact that this was actually sent to your office. So can you check that that was sent to your office? Can you check that that was in your office? Can you check that, I'm not going to get into personalities about who received it or who didn't, but it is, as Jim has referred to, Darrell Hagan. So can you clarify those things? I'm not asking, you may not have the information for you, but can you clarify
all of this is totally irrelevant.
It's not irrelevant.
Well, let me finish. It's totally irrelevant, and I'll tell you why it's irrelevant, because I think that you appear not to understand the workings of the office of First Minister. For any communication of such seriousness to be relayed government to government from a joint office where there's co-equal authority to a government department in Dublin requires the signature, consent of both Peter Robinson and myself.
And I expect you to take that up with the OFM side of your office as to why that didn't take place.
You're deliberately missing my point.
You're deliberately and trying to avoid the fact that information was passed to your office and special advisors for that matter, but that doesn't matter.
No, what does matter? What does matter in the running of a government, because many pieces of information float back and forward between all sorts of government departments and internally within government departments, and people make judgments as to whether or not they go to the minister, whether or not they are likely to find favour with the minister, or it's something that the minister should be involved in. It should not be lost on you. Should not be lost on you that the First Minister's side of OFM-DFM doesn't have the authority to send a communication purporting to be from the office of First and Deputy First Minister without my consent. And maybe that's a problem that the DUP have yet to come to terms with.
It's not a problem that I have, but it shouldn't be lost on you that an email was sent, following a discussion between the First Minister and you to your special advisor, providing them with the memorandum of understanding. What happened thereafter, I don't know, but that.
No, but what happened? You do know.
Sorry?
What happened in relation to the memorandum, so-called memorandum of understanding,
was sent to your office.
You do know, and you do know that it was sent from OFM, DFM, DUP side of the department to the Irish government without my authority. That's what you know.
Yeah, but
it wasn't worth the paper it was written on.
But do you accept you received it?
No, I never seen it.
But you accept your office received
I never seen it. No, how can I accept it if I never seen it?
Can you check?
Can you check?
We will check.
That's fine.
Absolutely.
Thank you, Chair.
Okay. Judith Cochran.
Thank you, Chair. Thank you, Deputy First Minister, for coming along. There's been a lot of things discussed today, all of which I'm sure are not within the terms of reference, and you know how keen I am to keep this within the terms of reference. I'm conscious about straying into other inquiries that may be ongoing. So if I can bring you back to our terms of reference, and I just wanted to check our objective 2, which is around the role and the establishment of the appointments and that to the Northern Ireland, the NAMA Northern Ireland Advisory Committee. You've already said that you had no issue with the appointments or anything. I'm just wondering, do you have any factual information relating to any subsequent relationship between DFP and members of the Northern Ireland Advisory Committee that you could have concerns about?
No, other than what has come into the public domain in the course of recent weeks. I have absolutely no information whatsoever about the role of Brian Roundtree and Frank Cushnahan in the aftermath of DFP appointing them as people who supposedly were to protect the interests of our economic fortunes in the north vis-à-vis fire sales.
So you have no concerns about that relationship, the ongoing relationship after those people were appointed?
Well, as a result of what has come into the public domain in the course of recent months, I have obviously very serious concerns. But those are subject to police investigations and investigation by this committee, all of which I support.
Okay, and the other objective then relating obviously to the actual sale of the Northern Ireland assets. You say obviously that you weren't aware at the time of everything going on, but that you are aware of that DFP were involved in meetings in advance of the sale. Have you got any facts on whether there were any relevant requirements or standards that weren't complied with?
No, I don't have any information about any of that, other than the concerns that have been raised in the course of the last number of months about how this was conducted and the very serious allegations that are being levelled at some of the people who were at the heart of it.
Okay, well, that's fine. Thank you, Chair.
Okay, Deputy First Minister, thank you very much for your time this morning. It's been a
Thank you.
Good luck.
Okay, members, given some of the comments the Deputy First Minister has made, and given there's clearly a conflict within OFM DFM about what happened and what didn't happen, I think it's clear than ever that the First Minister should also be invited to give his version of events, which has been referred to by some members. I think it's only fair that the other joint officer within OFM DFM come to the committee. Members be agreed to that?
Agreed.
Moving on then to the proposed briefing by Jamie Bryson. Fair members, page 62 of the main pack and page 164 of your tabled pack. Mr. Bryson, you're very welcome to the committee. A decision has been made that will not go into the detail at this stage. The committee are yet to make a decision as to whether to hear your evidence in public session. But what was proposed was that we hear from yourself what your broad areas are and how they fit within our terms of reference. So without going into detail at this stage, could you outline broadly how it fits within the terms of reference?
Well, Chair, what I would propose is I have a brief introduction before my evidence presentation, which does not stray into the evidence. I propose if I was to go through that, perhaps may be beneficial to the committee. Obviously, I'm conscious I don't want to stray into any areas of evidence you don't want me to stray into, so we'll follow your guidance on that. But before we go into that, I have to make clear, before I've come into the meeting, I have taken legal advice, and it is the opinion of my legal team that any decision to force this into a closed session may be unlawful and may subvert the power of the committee. So, pending a decision of the committee, I would need a couple of moments to myself to consult with my legal team and have a discussion as to whether I'm happy to proceed with a closed session or I want to move to a judicial review. But if you're happy enough, I will proceed with my introduction.
Yeah. May I just, if it's possible, Chair, that you ask Mr Bryson, just to state clearly which of the 4 objectives that he feels he's going to assist us with, because that's what we want. We want as much assistance to establish facts that we can.
Okay.
We have very clear objectives.
Do you want to ask him yourself?
We have four very clear objectives, which I'm assuming that you have read and that you understand, and therefore just if you, in whatever you're going to say now, can allude to which of those 4 items that you have information on, it'll help us then, and will help us then even in our questioning afterwards.
What I would propose, Ms Coughlin, is that I will go through the introduction, and if that is not sufficient or you wish to ask any extra questions, I'm open to that, and I'll take the guidance of the Chair as to, obviously this is quite a grey area as to making sure I don't stray into an evidence session in this, so I'll take your guidance upon.
Mr Chairman, I think I gather what Mr Bryson's going to do is simply read the introduction he had prepared already. The purpose of what we're doing now is not to hear the scene setting. The purpose is to identify what areas are germane to this inquiry and what direct contact you had with the major players, rather than simply basing it on hearsay. I'm not quite certain how the introduction actually meets our concerns.
Yes, Mr Wells, well, that's why I would be reading the introduction, to not set the scene, but explain how it fits to the terms of the evidence. I'm not sure if you've seen it before me, but I have it in front of me here.
Well, Mr Chairman, if at any stage Mr Bryson strays on the point that we're dealing with at the moment, I would expect you to immediately intervene.
I think it perhaps would be useful to start. Mr Bryson, you have sent correspondence in response to the committee letter last week, and you have named a number of areas. Perhaps just broadly go over those. I know you've made mention of Melmount. Now, Melmount clearly is within the terms of reference, and that NAMA and the Department of Finance and Personnel had a series of meetings relating to Melmount. So perhaps, without going into detail, how that fits within the terms.
Melmount is within the terms of evidence, obviously. Mr. The DFP met with Melmount. There are documents around Melmount and the lead up to the sale of Melmount and the subsequent happened with Melmount. There are documents which I think it's point 3. It relates to the committee is looking at effectively my leading off at anything that flowed from the sale of the NAMA Northern Ireland portfolio, and within that is obviously Surplus and their conduct, and if that reflects upon what may have happened prior to the sale of the portfolio. Again, there's documents to back that up. I can also shed some information on Fortress, and I know the committee are keen to receive information on Fortress, but if I could go through this, if at any stage you'd like to stop me, I'm more than happy. And again, I reiterate full respect for the committee and for this preliminary session, and I'm not going to stray into any evidence. And it's a matter for the committee whether you wish me to proceed and give this brief or you don't.
Okay, members.
Let's start. Let's get on with it. Yeah.
Mr Chairman, I wish to thank the members of this committee for hearing evidence to me today, and thank the committee clerk for the professional correspondence and the subsequent facilitation of today's session. I have the utmost respect for the integrity of this committee, and therefore I wish to make clear from the outset that all information I will provide today will be within the terms of the evidence, and indeed will observe the committee's guidelines for giving evidence. There will be no wild allegations or innuendo made by me today, and indeed did I dispute that I have ever made any such allegations. However, Chair, that is clearly a matter for a different day. I will seek at all times to ensure my evidence does not stray beyond the terms of the evidence or into ongoing live court cases, of which there is only one. That is the case brought by Graham's. It is a civil case and deals with a very specific issue. I have no intention of straying into this area, therefore there is no danger of prejudicing any ongoing court case. I again point out to the committee that there is no ongoing criminal case in relation to the sale of the NAMA portfolio, therefore it would be impossible to prejudice a case that is not yet and may never even take place. With that being said, I do believe that if there is any criminal wrongdoing, and I believe there is, by anyone associated with the sale of the NAMA Northern Ireland loan book, then those persons should face the due process of criminal proceedings through the courts. And in this regard, Chair, the last thing that I would want to do is give any potential criminals a get-out-of-jail-free card. With this in mind, Chair, I will follow your guidance and direction at all times throughout this session. All information I will provide today, I will stand over. I have never sought the cloak of privilege to provide this information, and nor will I seek to hide behind that today. If anyone feels that I have previously made false allegations about them, then there is a very clear path through the courts where they can take action against me to clear their name. I would think, Chair, that this would be the main motivation behind any action rather than seeking financial payment. I will go through my evidence in segments. Each strand of evidence will have a number of supporting documents. At the conclusion of my evidence session, I will furnish the Chair with this original copy of my evidence presentation, which will include copies of all documentation and evidence which I have referenced. I believe my evidence today will uncover an intricate web of political and financial behaviours that will show how there is an epidemic of cash for influence scams within the political, business, banking, accountancy and property development professions. It will raise serious questions and shine a light onto the you scratch my back, I scratch yours culture within the aforementioned professions, including, most seriously in my view, politicians using their influence gained via the democratic mandate to ensure favourable treatment for their friends and business associates. There is much information that is not included within my evidence presentation today because it falls outside of the committee's terms of reference. This information will be released in due course, and I firmly believe that a full public inquiry by an outside body will be required to get to the bottom of the huge magnitude of corruption that silently corrodes and perverts the political sphere within Northern Ireland.
Okay, members content to move the open session?
Yeah.
Reid?
Reid?
Well, Mr. Chairman, we now and then need to make a decision. Having heard, I assume that introduction is Mr. Bryson attempting to deal with the points that we've raised earlier, and I think we need now to discuss that.
Okay, Mr. Bryson, if you give me a couple of minutes, you can take your seat in the gallery, then we'll make a decision.
Just go ahead and get a wee drink of water and go to the toilet.
Absolutely. Okay, members, comments? Martin?
Well, Chair, I suggest you take this one chapter, as it were, at a time. That Mr. Bryson says he has documents, evidence to show that he has information used to this committee. Earlier today, we had lots of hearsay evidence bandied about by my colleagues across the way in their questioning. So I don't even think we should give him that flexibility. I want him to stick to areas in which he has been given knowledge which is of use to us in getting to the bottom of who was to benefit from the £7 million, £7.5 million payment or kickback that was coming via the Cerberus deal. I suggest we take him a chapter at a time, as it were, and that gives us an opportunity for you to control the meeting. But let's move into the evidence and see where it goes.
Well, yeah, I mean, again, from what Mr. Bryson has said there, he's alluding to stuff I'm still not 100% clear, but again, willing to give him the benefit of the doubt. But I think it would perhaps be useful for us as a committee if we actually take each of our 4 objectives in our terms of reference and try and ask him what factual evidence that he has against it. So, I mean, at this point, we're going to take evidence from him in open session, but I'm saying I think it would be useful. I think from what I'm hearing, I'm trying to see if I can tie. I think he's maybe tying stuff to maybe objective 1 and objective 3, maybe not so much on 2 and 4. So maybe we could start with those and rule those objectives out, and then get down into the nitty gritty of the specific things. Like for instance, objective 4 for us is about the role, functions and practices of the Law Society in regulating the profession of solicitors. I'm not quite sure, right? So there's something there, but the purpose of what we are doing is to find facts in relation to these 4 objectives. So for me, it would be helpful because there's so much information thrown out there, and it's very difficult to tie it into exactly what we're looking for. So I think that might be quite a useful way to start and be able to go through each point.
I suppose, that if you move above objectives to the purpose, the purpose is probably to undertake fact-finding review in relation to the operations of NAMA, including the project legal sale and related policy and regulatory issues that fall within the DFP remit. I presume that's on that basis rather than going through different objectives. If you with the purpose
help you with your questions if you go through your objectives.
Mr. Chairman, the issue here is what direct evidence Mr. Bryson hold. Now, he hasn't said anything in his introduction that convinces me he has direct evidence. It's hearsay, it's stuff read, been leaked, handed, but he hasn't any direct evidence of being involved in anything to do with NAMA. He's never met NAMA, he's never met Cerberus, he's never met any of the players. So therefore, there's nothing in that introduction that convinces me that he has met the criteria set out by Mrs Cochrane's amendment last week.
Well, clearly, I lifted the Millmount issue. Millmount, he said he has evidence relating to Millmount, and I don't know much about Millmount, but I know that was one of the primary items on the agenda for meetings between DFP and NAMA, between Sammy Wilson and NAMA. So that's well within our terms of reference. So I would be interested in that particular area in particular.
But, and I think, Chair, you know, within that, and again, this is going back to his paragraph 6 of his response to us, when he talks about documents relating to it, and he says that automatically makes it within the terms of reference. Makes it within the terms of reference if he is referring to DFP's action to Millmount or whatever. It's not necessarily in the terms of reference if he starts going on about the people being around the corner for me and all the rest of it. No, but all I'm saying to the Chair is that at that point, I would assume that you would
Yes, of course he will.
you know, stop that type of information.
Degree of flexibility, for example, as previous Martin McGuinness, but also in terms of Mr Graham as well. You know, so there may be things he says that you don't agree with, but I expect members to carry out their scrutiny role as well. If Mr Bryson makes points...
It's not about things I don't agree with respect, Chair. It's about things that fall outside our terms of reference, and I have been consistent in my approach to that with every witness that you have brought forward.
But what I'm saying in terms of members, if they want to hold this member of the public to account, feel free to do so. Mr Bryson will have an opportunity to put his case across, but there's an opportunity for members to say, well, prove it, give us more evidence, give us your sources. So I'm willing to give Mr Bryson his day at the committee, and I'm also willing to give as much freedom as members want to question him and interrogate him on the evidence he presents, and I think that's a fair way.
Just on that point, I appreciate that revealing the sources is one aspect, and we had it from Martine earlier on in relation to a correspondence that we received from Mr Tweed, acting on behalf of a number of individuals who remained unnamed, and as a consequence of that we said that we would not. We're taking one stance for one and another for another. So, you know, we have to be consistent in what we're doing here, and that's the point. Because if you're going to take that approach with him because he won't name them, we won't listen to him and we won't accept his correspondence. That's one aspect.
I accept that, but I think...
Okay, sorry, just Ian, and then I'll bring it back up.
I think we're missing the point. The committee took a decision last week that the decision to whether or not any, but I suppose Mr Bryson's the one in front of us, but evidence that we receive, we pass one of two tests, and either we decide that it's in public or private session based on what direct evidence is provided. Now, anybody could say in reference information that they have received or that they have, or evidence that they have in respect of Millmount or anything, that covers them in under our terms of reference. But there's nothing to show that there is direct evidence whatsoever. By having knowledge or being able to say, I know of what and I have evidence, does not cover the test that we set last week and passed by this committee that it had to be direct evidence. So we have to pass that one first.
Okay. Judith and John?
I take Mr Girvan's point about how we expect some people to be open and transparent about other things, and we're allowing other people to protect sources and that. But I do think that, you know, given what Mr Bryson has said, and he does say that he has documentation, etc., which we obviously haven't seen at this point, but I think in the interest of transparency and allow us to put weight to what he says, that as committee members it's really up to us to ask him before each question, for him to robustly demonstrate why he believes what he's telling us to be true, and whether that means he's going to provide us with documentary evidence to show it, or whether he's going to inform us as to where that information may have come from. That's the only way we can add weight to things. If he wants to talk about other things that he can't sort of substantiate, well, that's a matter for other people to decide whether it's worth listening to or not. But I think from what he said so far, I think we could proceed with caution at this point.
Okay, John?
Chair, my concern of this have always been more around the integrity of the committee and especially the position it puts you in as having to chair and know when someone has strayed into something that you might, I see at least the red button's closer to you today. But that has been my concern, both in his private correspondence that I mentioned earlier, and today there he has been at lengths to reassure the committee that he's not going to stray into anything or make wild allegations about anything else. So at that point, we've got to a point now that the committee has discussed this sort of at length on at least 3 separate occasions. So we probably have to make a decision one way or the other very soon.
Mr. Chairman, maybe
Jim, then Deputy Chair.
Could I maybe move things on by suggesting we move to a vote on this? I think the issue is so important that we should divide. We've been amicable on this issue, but I don't see a vote as being something to put a black mark against this committee or its chair. I see no evidence of direct evidence. The onus was on Mr. Bryson. He was given sufficient warning. He was very much aware of the decision this committee made, so he should have come prepared to show us the quantity of direct evidence he has, and therefore I'm proposing that the rest of the committee be held in committee.
Okay, so Deputy Chair, Leslie, Martin, and then Michaela, and then we'll go to a vote after that.
Sure, thanks. I'll be brief. I'm quite prepared to go ahead and listen and hear the evidence from Mr. Bryson.
Okay, Leslie?
Very much on the same line. I mean, it's quite clear some of the members have a fixed view on this. I believe we should hear the guy, let's see what it's all about, and stop this charade.
Martin?
Yeah, well, I want to agree with Ms. Cochrane. You know, let us proceed with caution. Not one question from my esteemed colleagues at the other side of the table today has helped us find out who is behind this fraud, this corruption. Not one question. It will help us find that out. And I have, over the many weeks of this, I think, and I hope this is accepted, we have not tried to abuse the office of the committee, but we have defended the right of the committee to hear witnesses. And today, I think that under your chairmanship, under the abundance of caution that Mrs. Cochrane urges, we should end this nonsense. There's some people desperate that this gentleman shouldn't be allowed to give his evidence. I think that the public is desperate to find out who is going to benefit from this fixed, crooked, corrupt deal, and I believe that Mr. Bryson will be able to help us in that. If he strays away from that or isn't helpful, Chair, I expect you to intervene immediately.
Okay, Michaela?
Yes, Chair, I certainly agree. Martin, we shouldn't be allowed to be engaged in hokey-cokey within the committee. I mean, it's going on outside the committee. We shouldn't allow others to allow it to happen here. It is in the public interest that we go ahead in public session. I think we have nothing to fear from what Mr. Bryson has to say. And I do believe members have already stepped outside of the terms of reference in their line of questioning to the previous witness. So I'm happy and content to go ahead in public session, Mr. Bryson's session.
Okay, members, we have one proposal from Mr. Wells.
Chair, do you want me to just recap then? One proposal from Mr. Wells, and then several members seem to be making a counter proposal. The first proposal from Mr. Wells, just correct me if I'm right, Mr. Wells, is that the oral evidence session be held following approach 2, which is meaning that the oral evidence from Mr. Bryson will be taken in closed session with no live transmission of proceedings, but with a verbatim transcript being published in a redacted form if necessary, with decisions on any redactions being taken on the basis of legal advice.
Absolutely right, yes.
Any other proposals?
Do we need the other one there that we simply go ahead under your chairmanship?
So option 1 then, if a member, is there a member formally proposing option 1? I'll just read that out then. Mr. Cree is proposing approach 1, which is meaning that the oral evidence from Mr. Bryson is taken in public session with the proceedings transmitted live and published in full in the official report by Hansard.
Which is a complete rescindment of what we agreed last week. It's totally overturning what we agreed last week.
Sorry, Chair, that is a decision that was taken last week of the two options, the two approaches.
Yes, we're going now for option one. If that was passed, that's option one, which was not what was agreed last week.
Chair, just to be clear, last week the committee agreed that its general approach with witnesses would be either of those two options, based on the decision in terms of direct link with the parties referenced in the terms of reference.
That's right.
Okay, members, take it to a vote. First proposal from Mr. Wells is for approach number 2. All those in favour?
Sorry, on what?
Option 2.
It's voting for it.
I prefer the approach.
All those against? Motion falls.
So then the proposal from Mr. Cree is approach 1. And just to remind members, it's meaning that the oral evidence from Mr. Bryson is taken in public session with the proceedings transmitted live and published in full in the official report by Hansard.
All those in favour? All those against? Motion carried. Okay.
Are we allowed a toilet break by any chance? No. Or do you have a bottle? I'm certainly apologising for a minute.
Members wish to suspend for 5 minutes? Or do you want to
go to conference?
Yeah, no.
Okay, we're going to take a
Sure, after these about 1 or so.
okay, 5-minute break, and then we're going on.
Committee room 30.
I was going to say, have you got sweets and granage clear?
No. I've got scone if you want a bit of a scone. I'm sharpened and I'm taking really strong painkillers at the minute, and if I don't take them, it hurts my stomach.
Okay, members, ready to make a start again? Okay, I just point out to the media, by the way, that all the coffees in this room have been purchased by members themselves and not the committee.
Austerity.
Okay, Mr. Bryson, you're very welcome. I'm going to give you an opportunity to put forward your opening statement now. We'll then move to questions from members. And just at the start, to outline again, as I have to other witnesses, that witnesses need to keep within the terms of reference and to present their evidence within the terms of reference and be mindful of the legal consequences of all of that. So,
The first strand of evidence that I'm going to take the committee through is Millmount. This evidence is highly relevant to the committee terms of evidence due to the fact that the former Finance Minister, who has recently left Stormont, Mr. Sammy Wilson, met NAMA in 2012 to discuss this site, and again on April 22nd, 2013, Mr. Wilson held a meeting with NAMA, and the first item on the agenda was Millmount. I note that I revealed the involvement of the Finance Department and the DUP in lobbying for Millmount some time ago, and it appears that following this and the subsequent following up of the story by local journalists in the Irish News, this committee has already sought clarity on DFP involvement in what amounted to, in my view, lobbying for the Millmount site, and ascertained that there were no minutes kept by DFP for these meetings between Mr. Sammy Wilson and NAMA. This, I'm sure committee MLAs and the public which you represent will agree, is absolutely remarkable. To set the scene around Millmount. The Millmount site was originally owned by companies controlled by Mr. Noel Murphy and Mr. Adam Armstrong. The site was then sold on to the Taggart Brothers for approximately $96 million in 2007, and this was financed through the Anglo-Irish Bank, which approved a loan for the purchase of the site despite Taggart's being in financial difficulties. In 2008, the Taggart Brothers business was placed into administration only a short period of time after they had purchased this site. Anglo had effectively financed the company that was heading for administration to purchase a Millmount site. This site was then placed under the control of an administrator chosen by the Anglo-Irish Bank. This administrator, along with the Anglo-Irish Bank, came to an agreement which would have resulted in Lagan Homes developing the site. Lagan Homes is owned by Mr. Kevin Lagan, who is involved in joint business ventures such as Lagmore Properties with Mr. Noel Murphy, Mr Murphy directly benefited from Tigard's purchase of the Millmount site, which was funded by the Anglo-Irish Bank in dubious financial circumstances, in my view. Following the setting up of NAMA, they were reluctant to continue on with the development deal that had been drawn up between the Anglo-Irish Bank, the Millmount administrators and the Lagan Group. The preferred option for NAMA and the administrators was to sell the site. At this stage, the Democratic Unionist Party had released public statements which warned against a fire sale and expressed concern over how NAMA would handle the Northern Ireland loan portfolio. It was in this climate that Mr Sammy Wilson embarked upon meetings with NAMA to raise the issue of the Millmount site. Evidence of these meetings taking place and the absence of any DFP meetings or the minutes of these meetings are already within the possession of the committee. NAMA then replaced the Anglo-appointed administrator with their own chosen administrator. It is also a point of some note that Mr Gareth Robinson, the son of the former First Minister Mr Peter Robinson, worked as a lobbyist for Lagan Homes, part of the Lagan Group. Mr Gareth Robinson was a lobbyist for Lagan Homes during the period that the DUP Finance Minister, Mr Sammy Wilson, took a keen interest in the Millmount site and lobbying NAMA. Mr Robinson, that's Mr Gareth Robinson, also holds, or at least held until very recently, an access all areas pass for this building. In April 2013, NAMA appeared to have a change of heart in relation to Millmount and released £9 million to develop the site. The beneficiaries were the Lagan Group, who, as previously alluded to, had engaged the services of former DUP Castlereagh councillor Mr Gareth Robinson. Whether the lobbying influence of Gareth Robinson, which in turn led to influence being exerted on NAMA by the then DUP Finance Minister Sammy Wilson, contributed to NAMA's change of heart, of which the Lagan Group were the beneficiaries at that time, is a matter for this committee to explore further. It is also a matter for this committee and the public themselves to judge whether this amounts to an abusive position by those with political influence on the basis of their democratic mandate. I am simply setting out the facts. It is for others to make a judgment upon them. Following the NAMA sale of the Northern Ireland loan portfolio, the Millmount site fell under the control of Cerberus. I can reveal today to the committee that the Millmount site is due to be purchased once again, from Cerberus, by Mr Paddy Kearney within the coming weeks. I will demonstrate later in the evidence session how Cerberus and Mr Kearney have developed a remarkably good working relationship, a relationship that appears to echo proposals that were originally made in a Memorandum of Understanding that was sent to NAMA by Mr Jeremy Gardner on behalf of the then First Minister, Mr Peter Robinson. It is a point of some note that the proposal was sent without the approval of OFM DFM and without the knowledge of the Deputy First Minister, as his evidence today ascertained to. Within the evidence tab, which the committee will be furnished with following the session, an email exists which has been redacted due to unrelated contents which will be outside the committee's terms of reference. The email is between Mr Paddy Kearney and Mr Pat Whelan. Pat Whelan was formerly of the Anglo-Irish Bank and was convicted in Dublin of fraud. Within that email, Mr Kearney says, "In another vein, I have been talking to Kieran McAlevey." Mr McAlevey was a banker in the Anglo-Irish Bank, or the Tigard lands at Millmount, and indeed other sites in need of planning input. I am more than happy to assist in any way I can. I am currently preparing some appraisals and thoughts which will hopefully assist Kieran, and I have already had some fact-finding discussions with my contacts in Coons, the original architects of the scheme, who have provided me with some info on the original application, which in my view was foolishly withdrawn. This remarkable paragraph within this email shows that Paddy Kearney had been working along with Anglo as far back as 2008 in relation to the Millmount site. NAMA eventually awarded a £9 million development contract to Lagan Homes before the loans were transferred to Cerberus, and Millmount is now heading to Paddy Kearney. The email also shows, in black and white, that the original architects of the Millmount site were leaking confidential application information to Mr Kearney. This in itself is astonishing. The Millmount deal is set to be completed in the first week of October for the consideration of £8.5 million and a further payment to Cerberus of £4 million if certain targets are achieved. This deal was funded by Chris Wilson of Jeffreys Loan Corps with the helpful valuation figure provided by Donald McCann of Lambert Smith Hampton, a chartered surveyors company which is based in Belfast. I can also reveal to the committee that another individual linked to the sale of the NAMA Northern Ireland loan portfolio, therefore firmly within the terms of reference, Mr Ian Coulter has recently become a director in 6 companies, 5 owned by the Lagan Group and 1 personal company which was coincidentally set up on 30th of January 2015, 2 weeks after leaving Tunes. Mr Coulter was also only appointed to all the directorships linked to the Lagan Company in 2015 following his departure from Tunes. His current directorship details are as follows, and supporting evidence is attached. Coulter Corporate Limited. This company was registered on 30th January 2015 and was jointly owned by Ian Coulter and his wife Victoria Coulter, who was also an ex-partner at Tunes. Ms Coulter resigned as a director on the 25th of February 2015 and formed a new company, Dummigan Limited, on the 21st of April 2015, and is the only director. Dummigan is Ms Coulter's maiden name. Antrim Asphalt Limited, a Lagan company. Ian Coulter was appointed here on 15th of June 2015. Lagan Holdings Limited, another Lagan company. Ian Coulter was also appointed to this company on the 15th of June 2015. Lagan Asphalt Group Limited, another Lagan company. Ian Coulter was appointed on 29th of April 2015. He replaced Kevin Anthony Lagan. London Limited, another Lagan company. Ian Coulter was appointed once again on the 15th of June 2015. Lagan Bitterman International Limited, another Lagan company. Ian Coulter was again appointed on the 29th of April 2015. This concludes my evidence in relation to Millmount. I will now progress on to the Project Eagle sales process, which is clearly relevant.
I'm just wondering, would it be helpful, because there's a lot of information that we've been provided with there, I'm wondering would it be helpful for some members if we could ask some questions at this point? And I know Mr Bryson says that he has sort of, you know, copies of emails and things like that. That would be quite useful to have to assist us in our questioning, because you're giving us a lot of information that we're just having to listen to.
Is there much of your presentation I have to go through? Or
Well, there's I suppose there's 3 more sections, which are all related to terms of reference.
You want to ask questions now?
The only issue, Ms. Coggan,
is the information you have.
Yeah, the only issue, Ms. Coggan, is the information is attached to this document. You know.
You haven't brought copies of it for us?
No.
Only for you to look at? Okay.
None of the section.
Okay, but it makes it quite difficult for
Yes, I understand.
It makes it quite difficult for us to ask relevant questions when you've bombarded us with information but not provided us with anything.
Perhaps it would be helpful to the committee. It may stall some time if...
You want to perhaps just continue and then come back to questions at the end?
Yeah. I'll now move on to the Project Eagle sales process. In the letter submitted to and publicly published by this committee, it states, Cerberus understands that its bid was the highest by a considerable margin. The minutes of the Doyle Public Accounts Committee of 9th of July 2015, which was sent to the Chair of NAMA, attached to a letter dated 4th of September 2015, established a number of facts as follows. NAMA set a reserve price in January 2014 of $1.3 billion, and under no circumstances would a bid be accepted for a lower amount. However, due to asset disposals and other factors, the reserve price was reduced to $1.24 billion by early April. PIMCO had made an indicative bid of between $1.1 billion and $1.3 billion, depending on due diligence. When PIMCO withdrew from the bidding process, only 2 bidders remained, Cerberus and Fortress Capital. Lazards, who were the advisors to NAMA, believed that there was sufficient tension between the bidders for a competitive bidding situation. Closing bids were to be submitted by the 1st of April 2014. Mr McDonough, CEO of NAMA, stated that 2 bids were received, one from Cerberus at $1.24.1 billion and Fortress at below $1.1 billion. Both arrived on the 1st of April, and the Cerberus offer of $1.24.1 billion was accepted on the 3rd of April 2014, and after review by Lazards and NAMA, the bid was reviewed by Lazards and NAMA within 48 hours. There are a number of serious questions to be asked as follows. Mr McDonough had already confirmed the reserve price was set, and to quote him, in early April 2014. Cerberus must have known that it was going to be $1.24 billion, as their offer was only 100,000 more, representing 0.008% over the minimum price. The reserve price was set, in Mr McDonough's own words, in early April. Cerberus managed to submit a bid almost identical to the reserve price on the 1st of April, and this bid was accepted on the 3rd of April. Why did Fortress offer less than the reserve price, knowing that it could not be accepted? Was this purely because it was a stalking horse? How could Lazards get it so wrong? It has been stated by them that bidding will be seriously competitive. So how can Fortress bid be more than $144 million, or 11.5% less than Cerberus? Who are Fortress Capital? I can now for the first time today reveal the links to Fortress Capital. The main man here is Mr Brendan McGinn, who is a disqualified chartered accountant based in Belfast. His closest friend is Gareth Robinson, and he has had numerous business ventures with Mr Paul Tweed, the original solicitor of Frank Cushnahan and the current solicitor acting for Mr Peter Robinson in his libel writ against Mick Wallace TD. Mr McGinn and Mr Tweed have been involved in private entity funds and media companies in both Northern Ireland and the United States, where they partnered with Fintan Jury, a former board member of the Anglo-Irish Bank, which lost over 30 billion of taxpayers' money, with hundreds of billions being transferred into NAMA, and then Cerberus. Evidence of the business links between Mr McGinn and Mr Tweed are attached in the documentation pack that will be given to this committee. Sorry, that should have been hundreds of millions of loads. I will now move on to section 4, and again I quote from Cerberus's letter, where they say, Cerberus aims to treat borrowers consistently and fairly. This section is again extremely relevant to the terms of reference by virtue of the fact that it deals with issues flowing directly from the sale of the NAMA Northern Ireland loan portfolio, and further to this I will demonstrate how favourable treatment of particular property developers echoes proposals made in a memorandum of understanding that Peter Robinson sent to NAMA. This was a document that was described by Mr Frank Daly, the chairperson of NAMA, as a, quote, debtor's charter. The statement Cerberus aims to treat borrowers consistently and fairly was recited in the letter submitted to this committee at paragraph 1.3.4. Unfortunately for some it couldn't be further from truth, and for others it was their saviour. The treatment of borrowers was vastly different depending on whether you were one of the chosen few or not. The best way to illustrate this is to look at a number of well-documented incidences supported by accounts. Paddy Kearney, EBN, Kilmona Holdings Ltd. Mr Kearney is from Belfast but has spent many years in the tax haven of Gibraltar. He would fly to the UK in his private jet regularly to oversee property deals in both Northern Ireland and the Republic of Ireland. He came into public focus when in early 2009 he was exposed as a member of the Maple 10, which bought shares in Anglo-Irish Bank from Sean Quinn to support Anglo's share price. The 10 borrowed €420 million. The mastermind behind the arrangements was Mr Kearney's close friend Pat Whelan, a director in Anglo-Irish Bank, who was later charged and convicted of criminal offences and is awaiting trial for fraud and theft charges. Mr Whelan was of course previously mentioned within this evidence presentation in relation to a leaked email I have provided which demonstrated discussions between himself and Mr Paddy Kearney around the Millmount site. When NAMA was formed in late 2010, Paddy Kearney's company, Kilmona Holdings Limited, debts were transferred to NAMA. The latest accounts for the year to 30th of June 2014 show a loss of $216 million. This is one of the biggest losses ever recorded by a Northern Ireland company. In addition, the company had a shareholders' deficit of some $223 million and therefore, to quote, was hopelessly insolvent and trading unlawfully. The auditors qualified the accounts as follows. With respect to certain year-end loan balances and loan interest payable, the audit evidence available to us was limited as we were unable to offer sufficient appropriate audit evidence in relation to the loan balances payable at the year-end and the loan interest payable in respect for same for the year. The loan balances were taken over by Cerberus from NAMA during the year, and we were unable to clarify the year-end balances of certain loans from Cerberus. Had this information been available to us, we might have formed a different opinion on the financial statements. We are unable to obtain sufficient appropriate audited evidence regarding year-end loan balances and loan interest payable by using audit procedures. In essence, therefore, the auditors would not stand over the figures, particularly the level of debt, and the company's legal advisers, Tunes, made no comment. At June 30th, the company owed the bank some $334 million. In the vast majority of cases, the borrowers, by now Cerberus, would have appointed an administrator to sell the company's assets and pay the proceeds to the banks. Cerberus took a different view, and instead of certain liquidation, they decided to write off in excess of $224 million, which meant the company only had to repay the lender approximately $110 million. Audited accounts are attached within this evidence tab to substantiate this. This money was to be advanced by Jefferies Loan Corps, which was on the list of Cerberus's preferred refinancers. In normal banking practice, one of the key criteria for advancing loans, particularly on property assets, is loan-to-value condition, whereby the property valuation had to be a certain percentage of the loan advanced. In this case, Donald McCann of Lambert Smith Hampton was commissioned by Jefferies Loan Corps to value PBM, which later became Kilmona Holdings, assets. Lambert Smith Hampton's original valuation was $85 million. which was clearly not high enough to fund a loan in excess of £100 million. As a consequence, within months, this was increased to £97 million, which was still not sufficient. Eventually, a valuation of £122 million was issued, which secured the loan to Kilmona Holdings Limited. I believe this way of doing business by valuers is termed travelling valuations. It is somewhat surprising that Lambert Smith Hampton engaged in such activity, particularly given that they had to settle a number of court cases over excessive valuations during the property boom, again where banks wanted higher valuations so they could lend more. A security deed was entered into on the 21st of January 2015, confirming this transaction I have just referred to. This is again included within the corresponding evidence tab. In summary, Mr Paddy Kearney was released from his guarantees and his company was forgiven over £224 million of debt. To celebrate this occasion, Mr Kearney hosted a dinner at a hotel in Carrickfergus, where the principal guest was one Mr Peter Robinson, who said he appreciated Jeffrey's Loan Corps' help to property developers. Mr Robinson and Mr Kearney have had a long friendship. Involved in organising the dinner on behalf of Paddy Kearney was a gentleman called Mr Alan Mains. Mr Mains is a former RUC and British intelligence officer who now works as a security consultant. Mr Mains has facilitated meetings between a select group of property developers and Jeffrey's Loan Corps and has been in regular contact with Cerberus through Mr Coggle, who is also a former member of British intelligence and got to know Mr Mains during their time in the security services. Jeffrey's Loan Corps' support to significantly indebted developers did not stop there. Paddy Kearney was keen to buy the assets of Mr John Muskelly, which included 10 Square Hotel and adjoining properties, and whose loans were again owned by Cerberus. Unlike their approach to Paddy Kearney, Cerberus adopted a very aggressive stance on the repayment of these loans and refused to write off any amount, but instead appointed their preferred administrator, Andrew Dolliver of Ernst & Young. Ernst & Young were appointed by Promotores Eagle Limited on 20th of January 2015, and the latter had a secured debt of less than £3 million, which was somewhat less significant than the valuation of the hotel. The first statement of administrators' proposals, which is attached, dated 16th of March 2015, made some astonishing comments, particularly in the view of the treatment of Mr Paddy Kearney, such as the company was unable to meet its debts, £3 million, fees a fee, £34 million. The primary task of the administrator is to dispose of assets and to pay initially secured creditors and then unsecured creditors. There is no record of a sales process being carried out, even though a significant number of businessmen had expressed an interest. However, Mr Paddy Kearney was selected as a purchaser for not only 10 Square Hotel, but all of Mr Muskelly's assets. The performance of Ernst & Young should be examined by this committee. It should be noted at this point that Ernst & Young had hourly rates as follows, and there's a table here of the hourly rates. I don't propose to go through it all. The committee will see it themselves at the end. But I can tell the committee that for the first 6 weeks of this work, Ernst & Young charged £52,500 plus VAT for their services. The previous paragraphs clearly illustrate that Cerberus does not treat borrowers consistently and fairly. Those with connections to certain politicians and their fixers can sidestep normal processes and even prosper while others are financially destroyed. There is no time at this hearing to produce further evidence of shady deals between Cerberus, Jeffrey's Loan Corps on one side and property developers such as Laggins, Armstrong, Murphy, Crichton and Boyd on the other. That will be for later. At first sight, it appears that each of the above are acting independently of each other in relation to NAMR and Cerberus, but this is just simply not the case. They have acted in unison with the same valuers, accountants, solicitors, ex-bankers and fixers keep appearing. The evidence is contained in numerous filings within Companies House, which anybody can access. It even goes further. As an illustration, Kilmona Holdings Limited was appointed by Salvera No. 1 Limited, the joint venture between Lagan Holdings and Mara Properties, to act as its agent under this deed for service of process of any proceedings before the English courts. Again, evidence of this is attached within the tab. Other issues which should be examined in relation to Cerberus's behaviour include why Crichton and Boyd's debts of £1.3 billion, the largest loan acquired, have not been dealt with and the personal guarantee has not been called in. In Cerberus's letter of 16th of September 2015, they comment in detail that they need to investigate new markets extensively and they need to speak to all relevant parties, including selected politicians, as they are a long-term investor. This is just simply untrue. Surplus acquired the loans in June 2014, yet on the 12th of August 2015 it was reported in the Irish News that Surplus had virtually completed his work, having recouped all of the knockdown $1.3 billion it paid for NAMA's loan book in little over a year. This is remarkable given Surplus referred to themselves as a long-term investor. As raised by Mr O'Muller at last week's DFP committee hearing, and a point that is hugely relevant to this query is the success fee that was to be paid to Tunes. This success fee was paid into a dormant Danske Bank account in the branch's Donegal Square West branch, and from there it was transferred to an offshore account. There were to be a number of beneficiaries to this fee, and I will refer to them simply as Person A, Person B, Person C, Person D and Person E. I can now tell this committee, without fear of contradiction, that Person A is Mr Peter Robinson, MLA. Person B is Mr Andrew Crichton. Person C is Mr David Waters. Person D is Mr Thank Cushnahan. And Person E is Ian Coulter.
Just at this point, Mr Bryson, do you have any evidence pertaining to that point, or I'm just concerned going slightly outside the terms of reference?
Well, I don't want to stray into ongoing investigations, but the NCA can seize the evidence and Tunes at any time. I don't want to stray into something here that...
Chairman, I must protest. This is exactly why we asked for a different procedure as far as the hearing is concerned. Because here we've had no direct evidence whatsoever from Mr Bryson. He's now moved on to make extremely serious allegations, and all he has is hearsay and his opinion. We have no evidence to support what he's just said.
Well, we do need to try and get evidence in regard to this, and members will be given an opportunity to contest that. But also, I would say the member he also mentioned Dara Hagan earlier on. We have no evidence to have there. So
but I had a written document.
Hasn't been submitted to the committee.
I had a written document in front of me with Darrell Hagan's name on it. We have absolutely nothing.
Well, the committee hasn't seen it, Jim, to be fair.
Well, Mr Wells, in the same token as how the committee dealt with Mr Graham, I have provided evidence. I am 110% to stand over that evidence. I will repeat the evidence outside of this room, and therefore without privilege. So if anybody takes issue with it, they can issue court proceedings to clear their name. I'm not seeking to hide behind privilege here today. Mr Gareth Graham gave what he believed was relevant information. I am giving relevant information to this committee, which sources extremely close and involved in this nefarious deal have provided to me as whistleblowers. I'm not in a position to breach somebody's confidence before this committee, but again, I will step outside the committee and I will repeat what I have said in here.
Mr Bryson, are you coming to a conclusion just so you open the statement?
Yeah, I'll just conclude the evidence. Yeah. It is clear from today's evidence that there are serious questions to be answered. I have provided factual and clear evidence today, and there is many valid questions. It is now up to this committee and other experts within this field to robustly interrogate this evidence presentation. I believe I have demonstrated a clear web of individuals, including politicians, who have contrived and conspired together to get things done and increase their own bank balances by a nod and a wink schemes. There is so much more information which I and others hold that could not be within today's document because it falls outside the constraints of the committee's terms of reference. These are issues such as how, ironically, parliamentary privilege has been used by politicians to make allegations against businessmen with the aim of discrediting competitors of their charmed circle of business cronies. I thank the committee for taking the time to hear my evidence presentation, and this concludes my evidence to this committee.
Thank you, Mr Bryson. It's very significant evidence what you put in front of us, and I look forward to seeing the papers that are to be provided to the committee as well. In terms of Fortress, Fortress has come up a couple of times, but we haven't really looked at them in any great detail. What is the relevance of Fortress, and could you tell us more about Mr Brendan McGinn that you referred earlier?
Well, the information provided, I'm just making sure I'm on the correct page here. In relation to Fortress, Mr McGinn is a key player within Fortress. I have demonstrated to the committee that I'm aware Mr Tweed wrote to the committee today claiming that to represent a number of individuals. I have just provided before the committee a link to show that Mr Tweed is in fact in business with Mr Brendan McGinn from Fortress. That may be a matter of a conflict of interest the committee may wish to look into.
What is this? I say just...
Sorry, the evidence provided there is just to show the link between Mr Tweed and Mr McGinn and companies where they are joint directors in. It may be a matter where the committee may take the view that it is of absolutely no relevance that Mr Tweed and Mr McGinn are linked in such a way, but I've provided the evidence and it's up for the committee to take a view on that.
In terms of Millmount, then, what you said regarding Millmount is of great concern. Obviously, there are a number of parties, and it's a very complicated web.
It is, yes.
It's very hard to keep up with all the information you've provided. But certainly there's linkages, there's crossovers. Obviously, Sammy Wilson had a big interest in Millmount in terms of his meetings with NAMA. It was number one issue in one of the meetings that he had on a quarterly basis with NAMA. Also, obviously, Cerberus, Lagans had an interest. Lagans employed Mr. Gareth Robinson. Paddy Kearney, Ulage is to benefit from this, and he is a friend of the First Minister, which has been documented in Irish News, and Irish News articles I've seen as well. And of course, Ian Coulter, that name pops up again. So do you believe then that in terms of the memorandum of understanding that came out of the First Minister's office from Peter Robinson's private secretary, that is somehow connected to Millmount?
Well, I'm no expert in this field. I am simply saying that it has been the opinion offered to me, and it's a matter for this committee to take a view, and other people more experienced in these matters than me, but it does appear that particular property developers are getting favourable treatment, as would have been the proposals within the Memorandum of Understanding. Again, I'm not in a position, and I'm not about to forensically make allegations in regards to that before the committee. That's for other people to look into. I'm simply providing the information, and it's up for the committee to take a view on it, and people who are experts in those fields to look into it. And the last thing I want to do is to start creating linkages and making allegations. I've provided the evidence. That's the links, and it's up for others to take a view on them.
So what is within the evidence pack relating to Carmona Holdings? You said the accounts were qualified and the accounts make reference to servers. Is that within
the accounts of Carmona Holdings in here, which shows the massive loss, and then the debts of, I think, I can't find the page, I think it was 224 million that was effectively written off for Mr Kearney. And it was after this, and this has been again reported in the Irish News, that there was a celebration party organised by Mr Alan Mains and attended by Peter Robinson after Mr Kearney secured this, which I would call, and others have described to me, as a favourable deal.
Stands, of course, in complete contrast to how Mr Gareth Graham was treated by Cerberus.
Well, I don't want to get into commenting on Mr Graham. That is a live case, and I don't want to.
Okay. Members, going to open the questions. Anybody?
Yeah.
Ruth?
Yeah, I mean, there are a number of questions I would probably like to ask, but as I've said, I've been given so much information, and perhaps whenever Mr Bryson provides us with a copy of all of this documentary evidence that he has, maybe the committee will forward him some questions or whatever in the future in the back of it, because I would imagine we will miss out on some of it. I just wanted to check, so in the interest of transparency and to allow any weight to be put to some of the stuff that you've told us today. You referred to names, the A, B, C, D and E. I can't even remember who they were because you went through them that quickly. Can you robustly demonstrate why you believe that is true? And when I say robustly demonstrate, I mean, have you got some documentary evidence to prove it, or has someone just told you that?
Documentary evidence is with the National Crime Agency, who will insurance.
Okay, so it's a matter for the National Crime Agency.
National Crime Agency have already been insurance, now they're in possession of paperwork.
Okay. That'll do me for now.
Deputy Chair, Martin.
Good afternoon, Mr Bryson. You said that Mr Brendan Kearney...
Paddy Kearney?
Sorry?
Mr Pat Kearney?
Sorry, Mr Pat Kearney had been afforded a very favourable deal.
In my view.
Yeah. And according to the figures that you gave us, Cerberus would have forgone a fair number of £1 million.
224 million.
Yeah, so they would have stood to lose a considerable number of millions on that sweet deal with Mr Kearney.
Yes.
Why, in your view, would Cerberus, who are out to make money for their investors, why would they forgo such a large amount, a potential large amount of money in favour of Mr Kearney?
Well, I have a very clear view on why. However, I gave my word to this committee that I wasn't going to come here on the basis of allegations or innuendo. So I don't particularly want to stray into giving my view on the links. I basically want to stick to providing the accounts. Let the members make a judgment on themselves on the basis of the accounts, on the basis of how other people were treated, and the links between these developers and certain politicians. I don't want to start making links for people, because the last thing I want to do is to allow people to controversialise this appearance and turn it into, making it out. Sorry?
In that case,
Oh,
so in that case, without making any allegations, but in an anonymised way, is it your view that certain politicians were lobbying Cerbis in order to achieve this sweet deal for
Absolutely, and of course it is a matter of fact, and it has been reported in the Irish News, it's in the public domain, that Mr Robinson actually celebrated the deal along with Paddy Kearney and enjoyed a meal in Carrickfergus. It's up for people to make their own conclusions on that.
And, apart from the report in the Irish News and the celebratory function that was held, do you have any firmer evidence?
Well, Mr Alan Mains was acting as a go-between. Mr Alan Mains is a close friend of the First Minister, Mr Peter Robinson. But again, I'm not going to start making leaps and links. I'm sticking firmly to the evidence I've provided, and it's for others to investigate that and look into them links. I'm not going to allow myself to be pushed into making innuendo or allegations that I can't substantiate.
Well, you obviously have a number of sources for your information.
Yes.
We supply you with information. Are you prepared to share those sources with the committee?
Absolutely not. I think, there's a vital principle, not only that, I think even the highest court in the land, I think it was a case against a journalist in relation to actually the murder of 2 British soldiers, refused to force a journalist to reveal their sources. I'm not a journalist, I'm a member of the public, but at the same time, if somebody comes to me and trusts me and gives me and asks for my word and provides me with something, I would go to jail before I will breach that confidence. So absolutely not, I will not be revealing my sources. But I think all through this and things that I've put into the public domain, and which has later, sometimes days, sometimes weeks later, been proven to be true, demonstrates that sources are on the mark. But again, it's a matter for the committee to investigate the questions I've raised today.
Yeah, you're right. You wouldn't have the sort of journalistic privilege that a professional journalist would have. But you have given have you given an undertaking then to your sources that you won't reveal their names?
If somebody comes to me and provides me information and asks for my word, I won't break my word. So.
Do you not agree that your evidence would be much more robust if you were able to provide us with the names of the sources?
Well, it's a matter for this committee to take a view on the decision, and it's a matter for the public and everybody else. You look at this evidence and you take a decision and say we're going to accept the bona fides of it and we're going to investigate it, or we're going to dismiss it, and that's a matter for this committee. And if what I've provided today is simply a tissue of lies, very quickly within investigation it will become clear it's a tissue of lies. So.
No, I'm not suggesting that you're telling lies, but what I am saying is, from your own point of view and even from the point of view of the committee, if the names of the sources were available, we would be on much firmer ground.
Well, it goes to the heart of the principles we have, and again, I'm not a journalist, but again, the courts won't even demand that a journalist reveals their sources. So I'm not going to do that. I'm not going to break my word to somebody, and and again, as I've said earlier, any of the allegations I've made today I will repeat outside of this room, so there is the avenue if anybody would like to commence legal proceedings to go ahead and commence them legal proceedings.
And some of this information you've already put out in the public domain.
Yes.
And have you been challenged legally to date?
I issued an initial blog, and I think that blog was issued at 11:15, and at midnight on that night, the Democratic Unionist Party issued a circular threat to all media outlets, which stated that anybody that referenced, mentioned the existence of, or even linked to that blog would be subject to legal action the following morning. I think that was 4 months ago.
But have you actually, has any legal action been taken against
No.
you to date? No.
I have published numerous allegations in the public domain based on the information of my sources, and nobody has commenced legal action against me.
Okay, thank you.
Martin?
Thank you, Mr. Bryson. I don't want to hurt your feelings, but you may not, and within some people in the community, you may not have be seen as a very credible witness. How can we be sure that you're not here because you hate the DUP even more than you hate Sinn Féin, and that really you do want to get the truth? Just finish. That you do want to get the truth and help the inquiry, and that it's not your animus towards these 4 upstanding gentlemen opposite that's motivating the evidence.
Well, again, the evidence is here, the links are here, and within the evidence pack you can see that it's factual, and you will see that there's accounts to back it up. And I have come here and provided the information which I have been given in good faith, and I have provided documentation and evidence.
There's a wasp there.
Wouldn't like to get stung, Mr. McVeigh, would you?
Don't bother me.
Sure. So, you know, it's no secret that I have absolutely no time for the DUP, but I'm coming here to provide evidence. And again, it's up for the committee and the public to take a view on that evidence. And if the public may listen to this evidence today and say, listen, that's full of nonsense, that's a political agenda, and dismiss it, the committee might take that view, or the committee might investigate this evidence and see that, well, actually, there's a lot of truth in it, and that's a matter for other people.
Well, I find some of the evidence persuasive, some of it, the parts I don't find persuasive. I do think, Chair, that as we interrogate the evidence in the time ahead and see the documentation, I do think that I would like to look closer at the relationship between Cerberus and Fortress. Purportedly 2 rival bids for the Cerberus bid, for the Cerberus, purportedly 2 rival bids for the NAMA portfolio, and I think it might be of interest to this committee to look at links, if any, between Cerberus. I'll leave it like that.
Paul?
Thank you very much indeed. Just want to pursue one area, and appreciate that you named the ABC, the NE names associated with that, and appreciate that you said that is on the back of information which is now in the hands of NAMA, or the NCA, as a consequence of their ongoing investigation. Did you, or have you, receipt of the official document associated where those names are mentioned on it?
The document's in the possession of the National Crime Agency.
Did you ever have possession of, or are you in possession of, the document which has...
I have had sight of a document. I am not in possession of it. The document is with the National Crime Agency, who were in Tunes a number of weeks ago and made an agreement with Tunes as to what documentation and evidence that they could take, and this includes emails, documents, and Tunes and the NCA had to discuss that between them. But again, we're straying into areas here of an ongoing investigation, which the DUP have been extremely
appreciate that.
Clear that we don't want to stray into an ongoing investigation, and you're now asking me to stray into it. So
no.
I think, with all due respect, the DUP need to make their mind up. Do you want to stray into the ongoing investigation, or do you not?
We're asking questions on what things you said in your...
Yes, and I'm making clear that is an ongoing investigation, and you're asking me to stray into it. I'm happy to stray into it. I'm more than happy to stray into it and go into the minute details of it. I'm more than happy to talk about offshore trust fund accounts and other things, but that will impact an NCA investigation. And if you wish to go down that road, I'm more than happy. I'm here and ready and willing.
We do not want to prejudice any possible criminal investigation that is going on or will probably come out of this whole saga. But I want to really know for a fact that what was said here today, you have documentary or have had proof of original documentary evidence of this, which is not just an evidence or an email that somebody has either fabricated and submitted, but it is something that is genuine. That's
I can assure you it's not fabricated, and I can 110% stand over the evidence that I have provided today.
Okay, Paul.
I think we need evidence here today, not allegations. You've done a strange way of dealing with this, because you've made your statement and then you say you're going to provide the evidence. You're going to provide written material. What written material are you going to provide?
I'm going to do exactly what Mr Gareth-Graham done and what the committee was happy enough with. I'm going to submit this whole document to the committee afterwards. Mr Wells, I'm sure you're presumably old enough to remember when George Foreman fought Muhammad Ali and he punched himself out, and the longer it went on, the more desperate he got. And as this goes on, the Foreman. So, you know, you get the documentation at the end of it. No, I'm not, but quite a to me.
What evidence are you going to provide that anyone lobbied Service for sweet deals? What evidence are you going to provide? You said that these deals have been done. What was the evidence?
Well, Mr. Wells, what I actually said, if you listen to my presentation, was that I provided details of Mr. Kearney's accounts. I provided details of links to politicians, and I leave it for the committee to make a decision on that.
But we haven't seen that evidence.
Well, you're going to receive this whole document at the end of it. And again, to be clear, Mr. Wells, I did not make that allegation. I did not make that allegation. What I said was that here is a particular set of accounts. Here is an individual who has appeared to benefit, and I was very, very clear, in my view, from a sweetheart deal. And here is how this individual is linked to politicians. For example, the former First Minister attended a dinner to celebrate these loans being wiped off. So it's entirely a matter for this committee to take up with the various departments, to take up with the DUP, or for you to take up internally as to what lobbying took place. I am raising the questions, and it's up for you to follow them up.
What evidence have you had that dinner in Carrickfergus?
Mr. Wells, it is clearly factual that there was a dinner in Carrickfergus. You know, if you'd like to go and ask Mr. Peter Robinson, he will confirm it. It's already been confirmed by the Irish News. I'm sure.
It must be true if it's in the Irish News.
I'm sure. Well, I know you have an issue with the Irish News because Mr. Robinson made that quite clear. But and if it's not true, why has Mr. Peter Robinson not commenced legal action against the Irish News? If the Irish News is telling lies, why is the Irish News not in the High Court being sued by the DUP?
So much of your evidence is based on what the Irish News has published, rather than
Absolutely not, Mr. Wells, because quite often I've published information before the Irish News, so it's probably based. The Irish News is probably based upon my evidence. So, you know, we're going round in circles here, Mr. Wells.
You aware just how serious the allegations you made when you named, allegedly named, Misters A, B, C, D, etc. You know how serious that is?
Yes, absolutely. And again, there's an open court process. I will make the allegations when I walk out the door, again, without privilege. And if somebody has an issue legal proceedings against me and prove me wrong.
And if any of this evidence you've provided is incorrect or wrong, will you apologise and retract?
Absolutely. Absolutely, I will.
Okay, thanks, Jim. Any other questions, members? And Jimmy, thank you very much for the evidence here today. What intrigues me is the Millmount presentation, part of your presentation, and the fact that Ian Coulter is involved in that Paddy Kearney, you allege, is set to benefit from this development, which now has had a £9 million investment from NAMA, and that also, in terms of the First Minister, his memorandum of understanding also seems to be in Mr. Kearney's interest, and also to this dinner in Carrickfergus. So you're right, there's a lot of things I think it's important to point out. The job for the committee is to work out whether there isn't connections,
absolutely,
or whether there is this web. But certainly this, I find personally, very, very useful. We need to interrogate the information, we need to look at the documents, and I think this underlines again the need for the First Minister to come before this committee.
And just to put it before the committee, if there's any questions on the basis of the document that you would like to ask me, I'm more than happy to now engage in written correspondence. If you want to forward me any questions, I'll be happy to supply it to the committee, and I thank the committee for the opportunity to appear here today.
It's not for Mr. Bryson, but he shouldn't leave the room without knowing that we like to speak to those sources. You're not a journalist, so I don't really put much time in the justification that you don't want to give us their names, but I'm not asking you for their names. What I am saying is that those people that have evidence and direct evidence, we would like to see them at this committee. One hopes and prays they're cooperating with all the different police services investigating this, but the message should go back to those people. For whatever reason they give you this information, the message should go back. We would like to see and hear from people who have their hands on the tiller of this case.
Thank you very much.
Can I just ask one question just before Jim goes?
Yes.
Why did the sources come to you with information, not come to the committee chairs with information? Why did it come through you?
Well, I suppose I would have to go away and ask them that and then come back to you.
Well, maybe if you would, just
what you asked me to do is you're asking me to speak on somebody's behalf. What you're asking me is to surmise what
Well, why do you
source might
think? Why do
say.
you think they come through you rather than just coming directly to a committee?
Well, again, you asked me for an opinion, and I can't give an opinion on somebody else's mindset. You know, I'm good, but I can't read people's minds.
Only asking it. I'm not going to get an answer.
No, well, I've given you an answer. I can't speak on somebody else's behalf. You want hearsay evidence when it suits you.
Yeah. I'm only asking a question.
Okay, members?
Thank you.
Members, can I just remind you about privilege the privilege this committee has, but members do not have privilege when they exit that particular door. So if you're doing any interviews outside, just be mindful of that fact. Mr. Bryson has agreed to give us some papers in terms of the handling of that. What is the official procedure?
I think in one sense, if you read his email, he said after his opening statement he would provide us with papers. It didn't happen, but that's a minor point, I suppose.
He's given them to Clark, I think.
I mean, I don't think it has allowed us to really effectively question him, to be quite honest with you. I mean, there may be other things that we want to probe. I mean, I would imagine that whenever this is copied for us, that we will all go through it with a fine-tooth comb, and those things that actually fall under the 4 objectives that we have, we may want to explore further, and anything else that sits outside it, we can fire on to the NCA, who apparently already are in possession of some of the information. I couldn't quite get that when he was saying he raised it, but he says, but that's something the NCA already have. Wouldn't give us more information on exactly what he had. It just got a bit... Is that within the terms of reference or not?
Just important to get those papers in the public record, of course.
Yeah.
Not actually follow it up with any
evidence.
Any evidence at all, never mind direct evidence.
I'm not sure we've heard really much more new today than what
we read in Irish news.
What we'd already heard, to be quite honest with you, which is a shame, because had we been provided with the papers in advance, we may have been able to scrutinise a bit more. But
how soon can members get a copy of the papers?
To get it scanned in.
Sure, yeah, we'll get it scanned, we'll get it out to members, and then the committee can decide the status of those papers, what it does with.
Okay, so that for tomorrow, members, or?
More or less.
Okay, members agreed. That's been provided tomorrow.
Yeah, agreed.
Chair, just one point that was raised, and it was around the stuff that's going to the NCA and around, I think you'd mentioned documents from Tunes and places like that that had been seized. Is it within our remit to ask the National Crime Agency, have they taken all the necessary steps to ensure that no evidence can be being destroyed? If their investigation or their process is quite slow at the moment, that there couldn't be any sort of tampering with electronic documents from any of the groups that are involved.
In terms of, we're meeting the NCA on Monday.
I'll raise it with them then, that's fine.
But is it an idea to have questions pre-prepared from them based on cases for other reviews?
Sure, it's an informal meeting with the NCA on Monday.
Yeah.
On
There's a number of members going to be present at that as well, the chair and the deputy chair, is that correct?
On her party?
Her party, that's correct.
Later in the meeting.
Are we going to share that document with the NCA?
I think we should.
Aye, that's what I'm saying.
Sure, once it goes out to the committee can then decide what it does with it, what status, what if there's markings or what it does with it. But we'll get it scanned and out to the members, and then we can make decisions in that regard.
So we'll make a decision next week whether we share it or not. That's fair.
Any other points, members? Okay, moving on to correspondence.
Okay. Just race through the correspondence requiring decisions. Chair, there's a lot of correspondence carried over from last week's meeting.
Is table packs or main pack, Chair? Main pack?
It's mainly the main pack.
What page?
Page 3 is.
Which page is correspondence on? Or?
Page 69. I'm starting.
Thank you.
So there's DFP October monitoring round, page 69 of the main pack. So it's for circulation. It's correspondence regarding the October monitoring round for circulation to the other statutory committees. Chair for given the cross-cutting interest, and members agreed. There's correspondence from DFP regarding equal pay issue, and that's at page 70 of the main pack. Again, it's of relevance to and an interest to the Justice Committee, and members are content to forward it on to the Justice Committee for information.
Chair, is that the prison officers' pay issue?
So this is at page 70 of the pack.
With equal?
Yeah. It's a reference to the letter of 3rd of July, which Mr. Denver regarding PSNI NIO equal pay inverted commas issue. Yeah.
Prison officers one's been agreed just recently.
So in terms of decisions, then at page 83 of the pack, there's a committee for OFMD-FM is writing in relation to the EU dossiers, basically given information in respect of the relevant policy areas within each department. So it's just there is a section there on pages 78 to 79 relevant to DFP if the committee wants to seek a written update from the department in terms of those areas. In the meantime.
Great.
So there's correspondence from the Scottish Parliament in relation to intergovernmental relations at page 212 of the pack, and it's relevant to the committee in terms of the committee's report on the Barnett formula. Give members an opportunity to look at that. Committee's raising issues basically that were identified by this committee in its report in relation to dispute resolution and intergovernmental relations, and it's raising raising the possibility of a continued engagement with this committee. This is a devolution further powers committee in the Scottish Parliament, raising the prospect of a further engagement with this committee around those issues of mutual interest. Just to, if members are content to respond, that the committee's interested and willing to kind of continue an engagement with the committee on those areas of mutual interest.
Great.
Correspondence from the Construction Employers Federation at page 214, again seeking to brief the committee, and the committee has had an engagement with CEF in the past, issues of relevance in terms of public procurement related issues. So it's just to check if the committee want to seek a written briefing in the first instance from CEF on the issues that it wishes to raise.
Great.
There's correspondence from the Bar Council at page 215, and this is in relation to the Legal Complaints and Regulations Bill, and the Bar Council is confirming representatives to come before the committee, but they're also wishing to extend an invitation to the committee to hold this evidence session at the Inn of Court. If the committee wishes, and members will recall there was evidence taken in relation to the bill at the Law Society headquarters. So if members are content, committee staff can ascertain the costs associated with it and come back before a formal decision is made by the committee. Obviously the committee would want to pay its own way in terms of lunch and so forth, so we'll come back in terms of costs. If members are content with that approach.
Great.
Then yeah, I think that's all the correspondence requiring decisions, Chair.
Okay, members, committee work programme pages 222 to 227, and just another reminder, the meeting with the NCA is to take place on Monday at 11:30. It was agreed one rep from each party would attend. Can advise members that while we may not yet have a fully cross-party representation confirmed, the arrangements will now need to be firmed up with the NCA for Monday in any event. Any other business?
Where were we meeting there, Chair?
We'll circulate members the details of the room, but it's 11:30 in Parliament buildings here.
Okay, members, next meeting will be 3rd of September, 10 a.m.